Everyone, I'm going to call to order the City of West Palm Beach Special Magistrate, hearing for this morning. It's March 5th. Verizon says it's 9 o'clock, so we can begin. My name is Amity Barnard. I'm the Special Magistrate for today's hearing. First thing I'm going to do is swear anybody in who's here to speak on any items on today's agenda. So code enforcement staff, as well as any respondents here for a code enforcement matter. If you could stand if you're able and raise your right hands for me. Perfect. Do you all swear or affirm to tell the truth, the whole truth, and nothing but the truth? Yes, ma'am. Thank you. You may be seated. A little bit about process. Nearly all of the items on this portion of the agenda are violation hearings. So when you hear your case called, you're going to come down to the podium here on my right side. City staff will come to the podium on my left. The city will present its case first, present any evidence it has, any witnesses it has, and give me their side. Once they're finished, you will have an opportunity to do the same. Say anything to me that you'd like, show me any documents that you have, cross-examine any witnesses that the city has put on, and at the end of that discussion, I will make a final ruling, and you'll get an order that reflects that ruling, either as you leave here today or in the mail. With that, keep in mind all of your testimony is given under oath, so with that, I will turn to the city to call its first case.
Starting with the contested building cases, case number 1, CE 23020178, case address 635 50th Street.
Morning, sir.
Good morning. My name is Saul Yarmish. I'm a city and building inspector. Code cases CE 23020178, 635 50th Street. The violation I observed was a garage conversion to living space. I issued the violation and posted the stop work order on the job on February 15, 2023. The notice of violation was mailed via certified mail and regular mail on February 12, 2025. It was posted at the City Hall on February 14, 2025. Was posted on the property on February 12, 2025. Certified mail was delivered on February 14, 2025. I observed the violation of a garage being converted to living space. The pictures being shown truthfully and accurately depict the alleged violation and reflect what I'm testifying to. Permits and inspections are required for work I observed and for what is displayed at the pictures shown. Permits have been issued. It was requested, but a resubmit was required. Inspections have not been performed. The resubmit for the permit was in August, the last time of 2024. So I have had contact with the owner, working with him, trying to get the permit or whatever is needed. As of August, something was done in November and in October and November. After recently after this hearing was issued to him, something went into the city today. So as far as I know today, it will be reviewed again.
Okay. And I just want to make sure I understood you. I think you said permits have been issued, but I think you mean permits were applied for, but they're still going through the process. Yes. Is that correct?
Yes. I'm sorry, yes.
Okay. And they resubmitted something today, so now it's back in the city's hands to review that. Okay.
So the city recommends 90 days to comply and $50 per day after that. The time to bring the alleged violation into compliance is a reasonable amount of time. I'm submitting as evidence a copy of the case file, including all documents relied upon.
Okay, thank you.
Special Magistrate, the city would like to enter the case file, including the photos and testimony, into evidence, barring any objection.
Thank you. Good morning, sir. Your name?
Good morning, David Aprea.
And your relation to the property? You're the owner.
I am the owner.
Very good. I see your name there. Thank you. So you've heard what the city is saying. It sounds like you have a permit application in and you're working through the process. Is that right?
Correct.
Okay. And you resubmitted something today?
I hired a company to do it,
Okay.
so that was my first mistake. Should have done it myself.
Right. All right, let's start with the easy part. You've seen the documents are scrolling on both sides of me, behind me, the notice documents, the pictures. That's the city's evidentiary case file. Do you have any objection to any of those documents being entered into the record?
No, I don't.
Okay. What has your contractor said in terms of time to get through the process? They're asking me to give you 90 days. That sounds like more than enough time. Would you agree?
At this point, I don't know.
Okay.
Like I said, I hired a easy permit to take care of this for me, and hasn't worked out so well. So I understand there was some paperwork submitted yesterday or today. He was supposed to be here at 9 o'clock. He's not here as of yet.
Oh, your permit person?
Yes.
Okay. Okay. Does the city have any idea how much stuff is still outstanding?
They have to, as far as I know, they were to submit another survey and some plan or something. I'm not 100% sure, but I'm being told that what was needed was submitted, just now has to go
Now it has
into
to be
review.
reviewed. Okay, so that's a good sign.
Yes.
I know that the value of the project was too low, so
Okay.
they bounced that back. I also know there was some permitting fees from the librarian also that were agreed to.
Okay,
But other than that, I don't know what else is needed.
okay. And in terms of what you witnessed, building inspector, you witnessed, I see the front door is pretty clear. Were there other modifications to that structure, or was that, they took out a garage door and put a front door?
There were people, it was converted to a living space.
Okay,
I was able to get inside.
okay, and you saw beds and whatever else
I
inside
don't
there?
remember if there was a bed, but it was a living space.
Okay,
I don't know if I had pictures of that.
okay. All right, I think, sir, 90 days should be, I mean, getting through the permit process, if the city's testimony is that the documents that they've asked you for have been submitted as of today, 90 days should be more than enough time for you to get through the remainder of the process. As you said, paying the fees, that's the easy part. Getting the required documents in is the harder part, so if that's in as of today, 90 days should be more than enough time for you. I don't see a need to give you more time than that. The city's review is usually pretty quick on the documents that come in. And given that they've stopped worked the project, you're obviously not using the space, right? So,
It's been 2 years.
okay, all right. Anything else you'd like me to hear, sir?
No, I bought it this way. And the second day I owned the building, I was working on it, and that's when he came by and shut us down.
Okay,
But there was really no work that was being done except cleaning up and repairing things.
right, okay. All right, anything else from the city?
No.
All right, in case CE 23020178, I'll enter the city's evidentiary case file as composite exhibit 1 without objection. I'll find, based on the notice documents in the case file, which include an affidavit of posting, that the city had good service for today's hearing. I'll find, based on the documents in the case file, as well as the testimony of the city staff, that the respondent's in violation of section 105.1 of the building code for the garage conversion without a permit. I'll require respondents to comply with that section within 90 days, or a $50 a day fine will be assessed for each day thereafter. So keep in touch with the city staff if there's any issues as you go through with your contractor, okay?
Very good, thank you.
Thank you, sir.
Thank you.
Case number 8, CEBLD 24070614, case address 325 Valley Forge Road.
Good morning, I'm Kevin Pennington, Building Inspector for the City of West Palm Beach. The code case number is CEBLD 24070614, and it is 325 Valley Forge Road. The violation I observed was a fence panel replacement and a pergola construction. I issued the violation and posted a stop work order on the property on July 22nd, 2024. The notice of violation was mailed via certified mail and regular mail on February 10th, 2025. It was posted at the City Hall and posted on the property on February 6th, 2025. Certified mail was delivered on February 12th, 2025. To support my observations of the violations of photos of the replacement fence panels and new pergola construction. The photos being shown truthfully and accurately depict the alleged violation and reflect what I'm testifying to. Permits and inspections are required for the work I observed and for what is displayed in photos shown. Permits have been applied for, permits have not been issued, inspections have not been performed. I include in my file is a copy of the notice of violation and affidavit posting. I've had contact with the owner. The results of the contact was the owner was proactive in complying. City recommends 30 days to comply and $50 per day fine after that. The time to bring the alleged violations into compliance is a reasonable amount of time. I'm submitting the evidence, a copy of the case file, including all documents relied upon.
Special Magistrate, the city would like to enter the case file, including the photos and testimony, into evidence, barring any objection.
Okay, good morning, sir. Your name?
Peter Adler,
And your relation to the property?
owner.
Okay. So you've heard what the city is saying. It looks like from the photos, clearly you got a new fence and a pergola.
It is an existing fence that was falling down because the developer on the next door started some work. We replaced the missing panels
Okay,
and rotten panels. One of the main inspectors who's been with the city for a long time, whom I know, I asked him, I said, what's going on here? Can I replace this? Do I need to pull a permit? And he goes, well, how much is it gonna cost? I told him, he said, listen, just fix it. Don't worry about it. Subsequently, the developer and I got into an argument regarding the fence's location and whether it was on my property, his property. He says it was on his property. By my survey that I got to get the fence installed originally in '99 showed that my fence was on the property line. We got in an argument. There were real estate attorneys involved. They just went back and forth. Subsequently, my attorneys, who you probably know, said, don't do anything until we figure this out. So we waited, blah, blah, blah. Anyway, this got long and drawn out. He got pissed off. He called this gentleman. He came in, saw the fence section, which is about 40 or 50 feet of originally permitted perimeter fence on my property, had been replaced. There was also a pergola that was originally there when we bought the house, and I also basically refurbished that. It's probably non-conforming because of the location on the property. But anyway, subsequently, I got the notice from him. We took what was up there down as far as the pergola. I am not going to put it back. I've already told him
so
that.
it's gone now.
It's gone. It's been gone. As soon as he gave me the notice to stop work, I took it down.
Okay,
The fence, however, was still in limbo at
Okay.
the time as to where it was on the property. Subsequently, we got the survey. The attorneys agreed to agree. The fence was relocated. It was actually, the survey was, property line was halfway between where mine said and his said, and the owner and I came to agreement. I moved the fence over 7 inches from the back to, there was 7 inches in the back to 0 at whatever point that was. So that was done. I'm at fault for not continuously following up on the permit stuff. That's on me. I'm not gonna argue with any of that.
right.
Unfortunately, I've got some out-of-state stuff going on with family. I take care of my nephew up in New York, and I actually flew in from there to be here.
Okay,
So 30 days should be more than enough It's done, I just need the permit and his inspection.
Okay, so you have submitted everything you need to the city, you're just waiting
Yeah,
for,
we've been going back and forth because originally I did it through my business, and then my wife, there were issues, she couldn't get access, and I was out of state, and she did it under my name, Peter Seattle Adler Portal.
okay.
And there's some confusion, she couldn't get access. To be honest with you, I really haven't had time to deal with it. I know that's not a good excuse, but it's
Well, I
my
appreciate your
reality, it's
honesty.
not
Yeah, I
yours.
understand, I appreciate your
It's
honesty
mine.
there.
So I just need to have the permit process finished.
Finished, okay. And the permit doesn't include the pergola, is that right? The permit's just for the fence?
Yeah, well, I did put a note on there that we're not going to install it, and if my wife, God bless her, needs to have it, then obviously I'll have to deal with that at another
Just
time. But I
separately,
told her,
okay.
I can't be dealing with that right now. I just
Okay.
don't have the time.
Okay.
So
And you said that you think 30 days is more than enough time for you to get through the,
it should be.
okay. The city, have you seen the pergola gone?
Yes, it's
So-
done.
Okay, so that's basically going away from this case then?
Yeah.
Okay, so we're just talking about the fence today. Okay. And from the city's perspective, there's no reason why 30 days, he can't get through the rest of the process in 30 days?
No.
All right, let me ask you, like you heard me ask the previous person, the documents that the city's asking me to enter into the record are up on the screen. That includes the notice documents for today's hearing, photographs. Do you have any objection to those documents being entered?
No.
All right, anything else you'd like me to hear, sir?
No, I don't think so.
Okay. Anything else from the city? All right, in case CEBLD 240700614, I'll enter the city's evidentiary case files composite exhibit 1 without objection. I'll find based on the documents in the case file, which include delivery confirmation from the USPS as well as an affidavit of posting that the city had good service for today's hearing. I'll find based on the photographs in the case file and the testimony of both the code officer and the respondent that the respondent's in violation of sections 110.3 and 105.1 for the fence without a permit. I'll require respondent to comply with those sections within 30 days or a $50 a day fine will be assessed. So keep in touch with the city staff. If
Yeah.
there's any issue, you don't come back to me again. So on the 31st day, if you don't have the permit issued, the fine will start. So if you have any
Gotcha.
issues, he likely will know, but make sure you communicate with him, okay?
All right,
Best of luck to you, sir. Thank you.
thank you.
Case number 9, CEBLD 241000658, case address 1830 Embassy Drive, 609.
Kevin Pennington, Building Inspector for the City of West Palm Beach. The code case number is CEBLD 241000658. The address where the violation occurred is 1830 Embassy Drive, Unit 609. The violation I observed was interior remodeling. I issued a violation and stop work order on the property on October 25th, 2024. The notice of violation was mailed via certified mail and regular mail on February 12th, 2025. It was posted at City Hall and posted on the property on February 6th, 2025. Certified mail was not delivered February 14th, 2025. To support my observations of the violation are kitchen and bathroom alterations, change of footprint in the bathroom, removal of a kitchen wall, flooring without sound underlayment, framing, drywall, electrical, plumbing work. The photos being shown truthfully and accurately depict the alleged violation and reflect what I'm testifying to. Permits and inspections are required for the work I observed and for what is displayed in photos shown. Permits have been applied for, permits have not been issued, inspections have not been performed. I include in my file of the copy of violation and affidavit of posting. I've had contact with the owner and the results was to apply for permits and complete all inspections. The city recommends 150 days to comply and $50 per day fine after that. Time to bring the alleged violations into compliance is a reasonable amount of time. I'm submitting evidence, copy of the case file, including documents relied upon.
Special Magistrate, the city would like to enter the case file, including the photos and testimony of the officer, into evidence, barring any objection.
All right, thank you. Your names for the record?
Well, my name is Alan Keene. I'm a general contractor. I try to take over. I'm here with the owner.
All right. And his name?
His name is Daniel
Andre.
Andre Corberry. You want me to spell it out, or you have the?
No, it's okay.
Okay.
All right, so you've heard what the city is saying. The pictures clearly show some remodeling inside. You've applied for a permit, and
Well-
you're working through that?
Actually, I got called in a couple weeks back. I went over there. I looked at the unit. I looked at the violation. I'm a state licensed contractor.
Okay.
And then we went ahead and applied. We got a process number that was issued, and now we're working on making this, right and get the inspection. And however, it's after the fact, but we'll work as much as we can throughout. And I just need kind of an extension, like you mentioned earlier, so we can take care of the situation, basically.
Okay.
But it's been applied for.
That's good. So you're moving your way through. He's asking me to give you 150 days, which should be more than enough time.
I agree with that.
Okay. Let me ask you, you've seen on the screens on both sides of me, behind me, the notice documents, the photographs that the city would like to enter their case file into the record. Do you have any objection to those documents being entered?
Well, like I said, when I walked in the unit, it was already done differently, so I can't really comment on what was done before, honestly.
Right, and that's fine. Your approval of the documents is just as it relates to them being entered into the record. Whether you can verify the accuracy of the photographs, I understand there may be some issue
I'm just
there.
saying, I don't want to commit to something I haven't seen before.
I understand that, so I'll go ahead and admit them over your hesitation. I think the pictures speak for themselves.
Yes, they do.
But I'll go ahead and admit the evidentiary case file in CEBLD 241-00658. Anything else you'd like me to hear?
Now, hang on a second. No, I don't think so.
Okay.
I mean, at this stage now, really no, and we'll try to solve the problem like within the period, and that should suffice, actually.
Right, and if you're a contractor, you know how the permit process works, so keep on top of it. When they put the ball back in your court, be diligent about it. 150 days should be more than enough time, but if there's any issues, let the
Correct,
city
and
know.
I got I got girls working for me for the permitting stuff, because we do it all the time, and
They do that all the time, that's right, so just,
I had my license since '96, so I think I got a pretty good
you've got a
glance at
handle
it.
on it. I got it. All right, thank you, sir. Anything further from the city?
Nope.
All right, in case CEBLD 241-00658, I've entered the evidentiary case file. I'll find, based on the documents in the case file, which include an affidavit of posting, that the city had good service for today's hearing. I'll find, based on the photographs in the case file and the testimony of the code enforcement or building official staff, that the respondent's in violation of sections 105.1 and 110.3 of the building code for the interior renovation done without a permit. I'll require compliance with those sections within 150 days, or a $50 a day fine will be assessed for each day that the violation continues. So same thing I told the previous person, the fine starts automatically on the 151st day. So if there's
Right.
any issues, keep in touch with him so that you can get
Sure.
on the same page with
No
the city, okay?
I have one more question, if I may. I'm just wondering, those pictures, I've never seen them before. Are they part of the file? Where can I retrieve that? Do you have them posted, or the ones that were just posted here?
You can
Public
get in
record?
contact with the city, you can do a public records request to get a copy of whatever they have in their case file for today,
Very good.
okay?
I'd like to see that.
Thank you, best of luck to you.
All right, thank you. Have a good day.
Yep.
Thank you, sir.
Case number 12, CEBLD 23110464, case address 610 10th Street.
Morning.
Morning.
My name is Raymond Stevenson. Code case number is CEBLD 23110464. The address where the violation occurred, 610 10th Street. The violation I observed is an interior remodel and windows throughout the house. I issued a violation and posted the stop work order on the job on the 11th of the 8th, 23. The notice of violation was mailed via certified mail and regular mail on the 2nd of the 12th, 25. Was posted at the City Hall the 2nd of the 14th, 25th. Was posted on the property the 2nd of the 11th, 25th. The certified mail was delivered on the 2nd of the 15th, 25th. My observation to support each violation were allergen, windows installed, interior, remodel, building, electrical and plumbing work done without permits and inspections. The pictures being shown truthfully and accurately depict the alleged violation and reflect what I am testifying to. Permits and inspections are required for work I observed and for what is displayed in the picture shown. Permits have been applied for, permits have been issued, inspections have been performed, but not all inspections are performed. It has been closed out. Included in my file is a copy of the notice of violations and affidavit of posting. I have had contact with the owner. The results of contact have been off and on just as a consultancy, helping them over the process of the permit and the inspections. The city recommends 150 days to comply and a $25 per day after that.
What did you say, $25 a day?
25, yes.
Okay, thank you.
The time to bring the alleged violations into compliance is a reasonable amount of time. I am submitting as evidence a copy of this case file, including all documents relied upon.
Thank you, sir.
Thank you.
Special Magistrate, the city would like to enter the case file, including the photos and testimony, into evidence, barring any objection.
Okay, perfect. Good morning, sir. Your name?
Richard Godfrey?
And you're the owner.
Yes.
So you've heard what the city is saying. It sounds like you have permits in hand and you've had some inspections, but you have some inspections remaining. Is that right?
Yes, I have a few inspections remaining. I was just waiting on my plumber to finish. He's been holding me up, but after that, I should get the ball rolling again, yeah.
Okay. And you heard the city they're asking me to give you 150 days to comply. That should be more than enough time?
Yeah.
You in
yeah.
agreement with that?
Yes.
Okay. Let me ask you the same thing I asked the previous people who have been here. The documents scrolling on both sides of me, those are the documents that the city would like to enter into the record. They're the notice documents for today's hearing, photographs. Any objection to that case file being entered?
Nope, no objection.
All right, thank you. Anything else you'd like me to hear?
No, that's it.
Okay.
Get everything completed within 150 days.
This one's pretty straightforward. You should be able to get through
Yeah.
your inspections. And if you can't get through those inspections in 150 days, we've got bigger problems, right?
Yes.
All right. Anything further from the city?
No.
All right. In case CEBLD 2311-0464, I'll enter the city's evidentiary case files composite exhibit 1 without objection. I'll find based on the notice documents in the case file, which include confirmation of delivery on the certified mail, as well as an affidavit of posting that the city had good service for today's hearing. I'll find based on the photographs in the case file, as well as the testimony of the city staff, that the respondent's in violation of sections 110.3 and 105.1 for the interior renovations that require a permit. I'll require respondents to comply with those code sections within 150 days, or a $25 a day fine will be assessed for each day thereafter. As you heard me tell the previous respondent, if there's any issues that create a significant delay, make sure you keep in touch with the city staff, okay?
Okay, sounds
All right,
good.
best of luck to you.
Thank you.
Case number 14, CEBLD 24080625, case address 815 39th Street, or Court, sorry.
My name is Raymond Stevenson. The code case CEBLD 24080625. The address where the violation occurred, 815 39th Court. The violation I observed is to replace the wrought iron columns with a tile wrapped around the wrought iron columns. I issued a violation and posted a stop work order on the job on the 8th of the 15th, 24. The notice of violation was mailed via certified mail and regular mail on the 2nd of the 12th, 25th. Was posted at the City Hall on the 2nd of the 14th, 25th. Was posted on the property the 2nd of the 11th, 25th. My observation to support each violation: your lurging wrought iron columns wrapped with tile. The pictures being shown truthfully and accurately depict and allege violations and reflect what I am testifying to. Permits inspections are required for the work I observed and for what is displayed in the pictures shown. Permits have been applied for. Permits has not been issued. No inspections have been performed. Included in my file is a copy of the notice of violation and the affidavit of posting. I have had contact with the owner. The results is what's happening is we're waiting for the historical, for the comments from the historical to see what further needs to be done.
I'm sorry,
regarding the
you're
road.
waiting for comments from what?
Comments from the historical, it needs to go through
Oh,
the historical side.
Okay, thank you.
And we're waiting for their comments. The city recommends 60 days to comply and a $25 per day after that. The time to bring the alleged violations into compliance is a reasonable amount of time. I am submitting as evidence a copy of this case file, including all documents relied upon.
Thank you, sir.
Thank you.
Special Magistrate, the city would like to enter the case file, including the photos and testimony, into evidence, barring any objection.
Okay. Good morning. Your names for the record?
Chauncey Freeman.
And your name, ma'am?
Denise Williams.
All right. You've heard what the city has said. They have photographs showing that you did some column work. You have a permit in, is that right?
Yes, ma'am. The permit is in, but it's been on hold since that time. Because when he gave us a stop order thing, that work had already been done a long time ago.
Okay.
So I don't understand. We weren't working on it at all. It was there. It just had been there. So I'll let my son finish explaining it to you because.
Yeah, that work was done almost 2 years ago. But I
Okay.
just got a notice like 6 months ago.
Yeah.
Okay.
So, and then they were like, oh, replace the router and columns. But I tried to replace them, but as I was fixing them, they were breaking in my hand. It was frail, so.
Okay.
So,
When did you apply for the permit?
The same
So
day
this-
that he gave me this notice, and the permit is in the system. It's just on hold by the historical committee, and he told me I can't do anything with it. I've sent all my drawings in. I sent everything, drawings,
Okay.
and,
So you say you applied the same day he gave you the stop work, is that right?
yes, I
So-
did.
So they applied
Yes, I
in
did.
August of last year and they're still waiting for historical
Yes,
review?
I sure am.
Yeah, again, I believe it's under the historical. I don't know why
Yeah.
it's been taking so long myself.
They said because of the historical committee is behind so far. That's what the girl told me the other day. I called down there and said, why is this taking so long? It's been on hold since that time.
Since August of last year?
He said, well, when it's on hold in September, when the historical committee got involved and said, no, we're gonna stop it or something, for some reason. But my home is not historical anymore because the city removed stuff from my house that, I live in a historical committee, community.
Right.
But they changed everything when they came out and redid my house about 10 years ago. They took my chimney away, they took stuff away and changed my whole outside of my house anyhow. So it's not the same house it really was. The only thing that we changed was the front porch because the wrought iron kept breaking it, you know,
Okay.
it just got so bad.
Okay. Does the city have an estimate on when they're gonna get through the historical review?
They say they're gonna do it today.
Nothing I would say, yeah.
Today is what they're telling you?
Yeah, that, the meeting is today, they
The
said.
meeting is today.
At 3:05, this guy named Ignatius, starts with Gnec,
Okay.
let me see how to spell it. Because I got an email from him right here. It's Ignacio is his first name, and his last name is Gneco.
Okay.
Yeah, he's supposed to have the meeting today, March 5th.
Okay.
And he said he couldn't do it no sooner, so.
Okay. So let me ask you the same thing I asked the previous people that you've heard. The documents that have been scrolling on the screen on both sides of me, those are the notice documents for today's hearing and photographs. Do you have any objection to those documents being entered into the record?
No.
Okay. So what I'm going to do is, it sounds like you're not the holdup here. If you've had your documents in, I'm going to give you a much longer time than the city is requesting, because it's not your fault that the city is still reviewing what you've submitted. So I don't think it's fair to penalize you if it takes longer. I'm not sure what the outcome of today's meeting is going to be, and it doesn't sound like the city has any additional information on that for me today. So I'm going to give you 150 days to comply, just like the prior case. That way you have more than enough time, given that you've submitted and you've been waiting for so long already. So if there's any issue with the city's review, keep in touch with the city, because if as long as you have everything you need to submit to them, submitted to them, you're doing your part. So I'm going to make sure you have more than enough time, because this is not your delay. This is the city's, just timing of schedule. I'm not sure what the issue is there, but I want to make sure you have more than enough time to comply, okay?
Okay, thank you.
All right, anything else you'd like me to hear?
No, that's it.
As far as the rod iron columns, they don't even make them anymore, so how can I comply with that?
So I can't speak to the technical aspects there. I don't know if the inspector has anything he can add on that.
Can I say a question? I think I had this discussion. Is the wrought iron columns still inside?
Yeah, they are.
Yes.
So if that's the worst case scenario, take it down and there's your columns still there.
It can't take it down because they're rotten. If I take it down, my porch is gonna collapse.
Okay.
That's why I braced them up.
Yeah,
Well,
I believe you can get wrought iron, but obviously it's going to be custom made.
Well, the historical committee, they asked for a copy of what we did,
Mm-hmm.
and they said that those columns can stay. And he just wanted to know how it was put together.
Okay.
So those columns can stay there.
Okay,
They already
great.
said that. Yes, we just needed to, they need to go through that this afternoon.
Their actual
And
meeting and review,
yeah,
okay.
uh-huh.
This way you have more than enough time, so if
Yeah,
there's
that's what I'm
any
saying.
hiccups that come out of the meeting today, you should have sufficient time to deal with the city after that.
Okay, then. Yeah, they can stay. That's what
Okay,
they told
that should make you get into compliance even faster, but
Yeah.
just so you have more than enough time, because you've already been in the process for quite some time, okay?
me. Okay, then.
All right, anything further?
No, that's it.
All right, anything further from the city?
No, thanks.
All right, in case CEBLD 24080625, I'll enter the city's evidentiary case file as composite exhibit 1 without objection. I'll find, based on the notice documents in the case file, which include an affidavit of posting, that the city had good service for today's hearing. I'll find, based on the photographs in the case file, as well as the testimony of the code officer or the city staff and the respondent, that the respondent's in violation of sections 105.1 and 110.3. And I'll require a respondent to comply with those code sections within 150 days, or a $25 a day fine will be assessed. So, as you've heard me tell the prior people, if there's any issue with the committee's review and there's any issue that you don't think you're going to get through the process, make sure he's aware of that, the city
Yeah.
staff, so that he can help you get to the point you need to be, okay?
Yeah, I've been staying on top of it.
Very
so
good.
that's-
Best of luck to you guys. Thank
Okay,
you.
thank you. You have a good day.
You too, thanks.
That concludes the contested building cases. Moving on to the non-contested, case number 7, CEBLD 24020512, case address 507 Purton Road.
Kevin Pennington, Building Inspector for the City of West Palm Beach. The code case number is CEBLD 24020512. The address where the violation occurred is 507 Puritan Road. The violation I observed was a room addition in the rear of the house. I issued the violation and posted the stop work order on the property on February 6, 2024. The notice of violation was mailed via certified mail and regular mail on February 10th, 2025. It was posted at the City Hall and on the property on February 6, 2025. The certified mail was delivered on February 12th, 2025. To support my observations of the violations are a concrete slab, wall and roof framing, sheathing, doors, windows, roofing. The photos being shown truthfully and accurately depict the alleged violation and reflect what I am testifying to. Permits and inspections are required for the work I observed and for what is displayed in the photos shown. Permits have been applied for, permits have not been issued, inspections have not been performed. Included in my file is a copy of the notice of violation and affidavit of posting. I've had contact with the owner, and the results are they was applying for the permits and complete all inspections. The city recommends 150 days to comply and $50 per day after that. The time to bring the alleged violations into compliance is a reasonable amount of time. I'm submitting as evidence a copy of the case file, including documents relied upon.
Special Magistrate, the city would like to enter the case file, including the photos and testimony, into evidence, barring any objection.
Can you go back to the photographs for me? So can you explain to me in that photo, is it where the blue tarp is? That's the walls, and is that what that is through the bushes there?
Yeah, you see the overhead, if you scroll the other way. Up, please. Yeah,
Other way.
you see that overhead photo there
Oh, yeah, okay.
of the house, and there's an arrow. That's where it's located. There's quite a bit of foliage to really get a good picture from the road.
But the picture right above that one, above the aerial, is that what you're seeing go up? Yeah.
Yeah, can you see like, you see the blue top?
Yeah, the blue roof, that's
Yep.
the room or structure or whatever?
Yep, yeah,
Okay.
they just added that addition on the back. rear
Okay,
of
and you
the
said
house.
permits had been applied for?
Yes, they have.
Okay, but they're stuck in the permit process?
Yeah, they have comments to resubmit, and that was as of October 21st, 2024. So it's been sitting a while.
So a long time, okay. Any communication with them?
Yes, I think they have another contractor on board now.
Okay, so maybe they'll
Seems-
start moving again?
Yeah, it seems like they've resubmitted, in the last few days with
Okay.
all the documents to get through plan review.
Okay. All right, thank you. In case CEBLD 240200512, I'll enter the city's evidentiary case files composite exhibit 1 without objection. I'll find based on the notice documents in the case file, which include an affidavit of posting as well as delivery confirmation on the certified mail, that the city had good service for today's hearing. I'll find based on the photographs in the case file as well as the testimony of city staff that the respondent's in violation of sections 110.3 and 105.1 of the building code for the work done without permits. I'll require a respondent to comply with those sections within 150 days, or a $50 a day fine will be assessed for each day that the violation continues thereafter.
Sorry. Case number 13, CEBLD 24100654, case address 700 North Tamarind Avenue.
Hi, my name is Raymond Stevenson. The cold case number is CEBLD 24100654. The address where the violation occurred, 700 North Tamarind Avenue. The violation I observed is a concrete canopy. Half the canopy collapsed, which was, as you can see, it's all been cleaned up. I issued a violation and posted the stop work order on the job the 10th of the 16th, 24. The notice of violation was mailed via certified mail and regular mail on the 2nd of the 12th, 25th. Was posted in the City Hall of the 2nd of the 14th, 25th. Was posted on the property the 2nd of the 11th, 25th. The certified mail was delivered on the 2nd of the 14th, 25th. The observation I observed, the concrete canopy was collapsed, needed permit and inspections. The pictures shown truthfully and accurately depict the alleged violation and reflect what I am testifying to. Permits and inspections are required for the work I observed and for what is displayed in the pictures shown. Permits have not been applied for, permits have not been issued. Inspections have not been performed. Include my file is a copy of the notice of violation and the affidavit of posting. I did initially have a contact with, I believe, was an owner agent, and that was the first day I went to the job, and she says that she was going to take care of the engineering on that first day, and nothing's been done over 2-3 months. The city recommends 120 days to comply and $150 per day after that. The time to bring the alleged violation into compliance, I believe, is a reasonable amount of time. I am submitting as evidence a copy of this case file, including all documents relied upon.
Special Magistrate, the city would like to enter the case file, including the photos and testimony, into evidence barring any objection.
All right, thank you. And you said the fine amount was 150?
Correct.
Okay.
Fine, 150, yes.
Thank you. All right, in case CEBLD 24100654, I'll enter the city's evidentiary case files composite exhibit 1 without objection. I'll find based on the documents in the case file, which include an affidavit of posting and delivery confirmation on the certified mail, that the city had good service for today's hearing. I'll find based on the photographs in the case file and the testimony of city staff that the respondent's in violation of sections. I guess let me ask you, you have 116.1 cited on the agenda for abatement. Are you looking for abatement?
No.
Okay, you just have it cited for the unsafe structure component?
Yes.
Okay. And do you have 105.1? That's not on the agenda, but do you have that cited? Can you go back to the notice? Go up for me on that.
Yeah, 116.1 unsafe building. And inspections, 110.3. Is for the inspections, required inspections. What's your question?
I guess you didn't cite them for not having the permit though, right?
Yeah. No, I didn't. You're right. For inspections. Yeah, I put it as an unsafe building, thinking.
So what are
thinking
you
that
asking?
then, yes.
So you're asking me to compel them to have the inspections done within 120
No,
days?
they need a permit.
Let me ask the city attorney. He didn't cite them for the section that,
Yeah, without notice of that citation, I would say that we wouldn't be able to proceed on that specific violation today.
Okay. Given that, what do you want me to do? I'm not sure that the inspections are actually required without the permit, right?
Yeah, my mistake. Just thinking that unsafe building, you need permits. But I should have been specific.
Is the document that's on the screen, is that the notice of violation? Yes. Okay.
If I could just have one moment,
Yeah,
Special
sure.
Magistrate.
Take your time.
Yeah.
Sorry about the delay, Special Magistrate. So the city would like to, at this time, will table or continue the matter under 110.3 as to the required inspections. But the city would like to pursue the abatement of this structure at this time. And we could rely on further testimony from Mr. Stevenson on that regard.
Okay, so you'd like to proceed with just the 116.1 violation?
Yes.
All right, so I guess give me your testimony as, the pictures are pretty clear, but just so the record is clear, explain to me why that's unsafe, and explain to me that whether or not that rises to the level of a health, safety, welfare issue or a danger to the public.
Why it's unsafe? When I first went there was a guy up on the roof. He was jackhammering, getting his, what you call a street saw, cutting the concrete, because the canopy had collapsed. And then if you go there around 4 o'clock when the school finishes, there's lots and lots of kids around this canopy. So it's a big concern.
All right, it poses a danger to the public and to the health, safety, welfare of the public?
Yes.
Okay. All right, so in terms of the remedy, do you want just authorization to abate, or do you want to give them some short time frame to comply?
No, they need to abate. They've had enough time.
So just immediate abatement is what you're
Yes,
after, a finding that
yes,
the structure is
immediate
unsafe and immediate abatement?
You don't want a fine to accrue?
And what?
You don't want a daily fine to accrue?
Yes, absolutely.
How would you abate that?
Good question.
I don't know if there's any way the city can abate that violation.
what I was-
I'm thinking we're gonna ask for a very short period of time because it's so dangerous, and then ask for a immediate fine, like say 3 days or 5 days, and then a fine of $250 a day or something to that effect.
Okay, so not even authorization to abate, just make it safe or block off the street or whatever, block off the sidewalk, whatever they need to do to remedy the unsafe component, and then an immediate fine after that?
Yeah.
Okay. Given that they're not here, I think 10 days is probably reasonable, just for them to get the certified copy of the order. And then I'm fine with the $250 a day fine.
I'm saying 10. Is it
10 and 250.
All right, anything further from the city?
No.
All right, in case CEBLD 241-00654, I'll enter the city's evidentiary case file. I think I already did as Composite Exhibit 1, but I'll do it again in case I didn't. I'll find, based on the affidavit of posting and the certified mail delivery confirmation, that the city had good service for today's hearing. I'll find, based on the photographs in the case file and the testimony of city staff, that the respondent's in violation of Florida Building Code Section 116.1 for the collapsed awning or balcony, whatever we're calling that. And that, based on the testimony of the city, that presents a safety issue, a health safety issue for the public. I'll require respondents to comply with that section within 10 days, or a $250 a day fine will be assessed for each day that the violation continues thereafter.
Case number 15, CEBLD 24120675, case address 411 14th Street.
My name is Raymond Stevenson. The code case CEBLD 2420675. The address where the violation occurred, 411 14th Street. The violation I observed is a roof work done without a permit and inspections. I issued a violation and posted the stop work order on the job on the 12th of the 2nd, 24. The notice violation was mailed via certified mail and regular mail on the 2nd of the 12th, 25th. Was posted at the City Hall on the 2nd of the 14th, 25th. Was posted on the property on the 2nd of the 11th, 25th. My observations to support each violation: I'm alleging roof work done without a permit and inspections. The pictures being shown truthfully and accurately depict the alleged violations and reflect what I am testifying to. Permits and inspections are required for the work I observed and for what is displayed in the pictures shown. A permit has been applied for. Permits have not been issued. Inspections have not been performed. Included in my file is a copy of the notice violation and the affidavit of posting. I have had contact with the owner / contractor. The results of the contact is that he's working on the permit comments. The city recommends 60 days to comply and a 50-day per day after that.
What was the fine amount? $50?
$50, correct. The time to bring the alleged violations into compliance is a reasonable amount of time. I am submitting as evidence a copy of this case file, including all documents relied upon.
Thank you, sir. Special Magistrate, the city would like to enter the case file, including the photos and testimony, into evidence, barring any objection.
Are you here for this case, sir?
Yes, I am.
All right, what's your name?
Peter Jean.
You need to be sworn in.
You sure do. Can you raise your right hand for me? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, what's your relation to Trevi Capital?
I'm the owner.
Okay, very good. So the documents that you see scrolling on both sides of me are the documents that the city would like to enter into the case, into the record. It's their evidentiary case file. Do you have any objection to those documents being entered?
No, I do not.
Okay, and this, you've heard what the city is saying. They're saying that you've applied for a permit, but you don't have the permit issued yet, and you haven't had inspections. Is that correct?
Yes.
Okay. Where are you in the permit process?
My contractor, he pulled the permit, and it was supposed to have been issued already, but I'm not sure what's going on. I guess there were some delays with the city and at the building department, so we're still waiting for that to be issued. So the fees, all permit fees have been paid, everything has been done, we're just waiting for it to be issued.
Okay. Can the city confirm whether or not the comments are in the city's hands at this point?
It is, it's in the city.
Okay.
We're just waiting for the comments, yes.
But your testimony was that 60 days is enough time for them to get through the rest of the process?
I believe so, yes.
Okay. 60 days, if you have everything paid for and submitted, that should be plenty of time.
Yeah,
Any
it should
reason that you don't agree with that?
No, it's fine.
Okay.
Mhm.
All right, and no objection to the documents being entered?
No, none at all.
Okay. Anything else you'd like me to hear?
From my end?
Yeah, from you.
No, that's all.
Okay. Anything else from the city?
No, that's it.
All right, and CEBLD 24120675, I'll enter the city's evidentiary case file as composite exhibit 1 without objection. I'll find based on the notice documents in the case file, which include an affidavit of posting, that the city had good service for today's hearing. I'll find based on the photographs in the case file as well as the testimony of city staff that the respondent's in violation of section 110.3 and 105.1 of the building code, Florida Building Code, for the roof work without a permit. I'll require respondent to comply within 60 days or a $50 a day fine will be assessed for each day thereafter. So I don't know if you were here and heard me say to the previous respondents, but if there's any issue that creates a delay for you, make sure you keep in touch with the city so that you can stay on the same page with them, because you don't come back to me for another hearing.
Okay.
If you
I
don't have the
will.
permit issued and the inspection's done within 60 days, the fine will start running on the 61st day, okay? So
Okay.
if there's something that happens that is beyond your control, make sure you're in contact with the city, okay?
Okay, I will.
Okay, very good. Best of luck to you, sir.
Thank you.
That concludes the building cases. Moving to the contested regular code cases. Case number 6, CE 25013270. Case address is 1401 Clare Avenue.
Good morning, Kevin Levine, City of West Palm Beach Code Enforcement. The business Crust and Company Wood Fire Fried Pizzeria, located at 1401 Clare Avenue, was cited for failure to renew its business tax receipt, BTR penalties, and certificate of use in violation of City Codes 82-144, 82-143C, and 82-22-A. On January 27, 2025, a notice of violation identifying the violations and my contact information and this hearing date was sent to the business owner. The notice of violation was sent regular mail and certified mail on January 27 and signed for on January 30th. Both the business and City Hall was posted on February 4, 2025, and a completed affidavit of posting is in the case file. I've had several discussions with the business owner, according to him, he was in the process of changing the business name, so I sent him an application to fill it out, send back to me. However, he did, when he filled out the application, he sent it with the current business name, so I had to send it back to him, and there was some delays, but he's here. In any case, the city is asking for 30 days to come into compliance and a one-time fee of $250 if not in compliance and a daily fine of $100 for the COU.
What was the last part? I'm sorry?
A one-time fee for $250 and a daily fine of $100 on the COU if he doesn't come into compliance.
$100 a day for the COU?
Yes, ma'am.
Okay. All right, your name, sir?
Jeremy Bonilla.
And you're the owner?
Yes.
Okay. So you've heard what the city is saying. It sounds like you're in process of getting the business tax receipt and certificate of use, is that right?
Yeah.
Okay. Can you get that done within 30 days?
I can, yeah. I have an application here. I've tried to come back like 2 weeks ago to try to get it figured out, and they told me that I had to re-register, and I did, because they couldn't find me in the system.
Okay.
And I came back a couple days later, and I tried to turn in the application, and they said that they needed whatever I did on Sunbiz to be approved by him.
Okay.
So that's all I'm waiting for.
Okay. So is that right? It's back in your hands, or that's not right?
That is not right. The city of West Palm Beach Code Enforcement doesn't approve Sunbiz, don't give Sunbiz approval. What happens is that the applicant applied to Sunbiz, and he or she is supposed to follow up with Sunbiz to see if the registration came through. It generally doesn't take no long period of time. I'm not sure what was said on the inside, but generally what he would do is resubmit the application. They would go into Sunbiz and see if the application was approved before they could.
So he's still in the process of changing the name with the Division of Corporations. You
Yes,
don't have an
ma'am.
application that has the new name on it yet?
No, ma'am.
Okay, do you understand what he's saying? So there's two separate processes. You have to change your business name with the Division of Corporations, with the Sunbiz people.
Okay.
Once you've done that, you resubmit your application to the city, but he checks your application against the Division of Corporations to make sure that the name on your application matches what you're licensed to do with the state.
Okay.
So make sure, I want you to understand, you need to finish, the city doesn't have anything to do with the Division of Corporations part of the process. You need to finish that part. And that's been my experience too. Usually those turn around within a week or two,
Yes, ma'am.
once you submit. But you need to get through that state process and then resubmit to the city so that the city can approve and move you forward in their process. Do you understand that?
Yeah.
Okay. And you need to do the state portion sooner rather than later, because 30 days is a lot of time, but you need to get through the state process before the city can finalize you in their process. Okay?
Yeah.
What's the last communication you had with the Division of Corporations?
It was 4 days ago. I got an email from them. I don't
Okay,
know.
so you're getting closer with them?
Yeah,
Okay. All right, and you think you can get through all these processes within 30 days?
I think so, yes.
Okay. All right, anything else you'd like me to hear?
That's it for me.
Okay, let me ask you the same thing you've heard me ask the prior respondents. Any objection to the documents, the evidentiary case file that's been on the screen? Any objection to those documents being entered into the record?
No.
Okay. Anything further from the city?
Now, I want the respondent to keep in mind that 30 days is a generous offer for the simple fact that back in December of 2024, I went over there and spoke to every one of them, to have them renew their business tax receipt, and was basically ignored. This is why we are standing here today. So 30 days is a very generous offer.
Okay, so what he's making sure that you understand is that he's giving you more time to comply, but you're not going to get any additional time. So do what you can do to get through the process within those 30 days so that you, with all due respect, don't have to come back here, okay?
All right.
All right. In case CE 25013270, I'll enter the city's evidentiary case file as composite exhibit 1 without objection. I'll find, based on the affidavit of posting and the signed certified mail in the case file, that the city had good service for today's hearing. I'll find, based on the testimony of city staff as well as the documents in the case file, that the respondent's in violation of sections 22-32A, 82144, 82144C. I'll require respondents for the certificate of use sections to comply within 30 days or face a $100 a day fine for each day that violation continues. For the business tax receipt, given that it's been delinquent for the period that it has, I'll assess a one-time fee in the amount of $250, okay? So get done with the state's process and then resubmit to the city so that he has current documents so you can get through in 30 days, okay?
Okay.
All right, good luck to you, sir.
Thank you.
Case number 11, CE 25013191, case address 2269 Indian Road. And I do think he might need to be sworn in. I don't know if he was.
He does.
Okay, thank you.
I do what? Need to be sworn in.
I have been? No,
Raise your right hand for me. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Go ahead, sir.
All right, before we get started, I just want to let everyone know this is the tenant, not the owner. But the tenant is the one generating a lot of the violations that are found on your property. With that being said, City of West Palm Beach Code Compliance Officer Paul McFarland. On January 14th, I was conducting a inspection with a complaint from the fire marshal, along with the fire marshal, building inspectors, and PD on this property with numerous complaints. The property located at 2269 Indian Road. At the time of the inspection, violations that were found were 94-6, restrictions upon land use, residents living within trailers found on the commercial property. Property was also cited for 94-272, permitted use table, primarily for the housing of residents in the trailers throughout the property. The property was also cited for 82-144, business tax receipt. They're including the tenant that's here now. There's a business being ran from that location with no business tax receipt. There are a number of other businesses being ran from that location that I observed. They are also required a business tax receipt to do any type of service or business from that location. The property, as well as City Hall, was posted February 20th. Certified mail as well as regular mail was sent January 15th. Certified mail was signed for February 27th. I've had no contact with anyone before today. I just made contact with the tenant that is here now. With that being said, city's recommending 30 days to bring the property into compliance for 94-6 and 94-227. City's requesting 30 days or $150 a day until compliance is achieved with that. And for the business tax receipt violation, city's recommending 30 days or a one-time fine of $250.
Thank you, sir. Mr. McFarland, did you take the photos that we've been shown here today? Did you take these photos yourself?
Yes, I did.
And do you believe that these photos accurately depict the code violations that you've alleged here today?
Yes, as you can see, there's a number of different type of businesses being ran. I mean, there's auto shop repair going on in there. There's body repair going on there. And there's no record of any of those businesses being ran from that location, including the gentleman that's standing here. He basically seemed, what I'm understanding from hearing from other people at this property, he's basically the overseer, as you may want to say. But what he's doing is basically leasing out spaces to these businesses. He does need to have a business tax receipt for whatever business he's doing there. I don't know what it is. He would have to testify to what he's doing there, but whatever it is, it's required a business tax receipt.
Thank you, sir. And do you believe 30 days is a reasonable amount of time for this property, the tenant, to come into compliance for the alleged violations?
Yes, sir.
Thank you, sir. Special Magistrate, the city would like to enter the case file, including the photos and testimony, into evidence, barring any objection.
All right, thank you. Your name, sir?
My name is Scott Kipp, K-I-P-P.
And your relation to the property as tenant?
Well, first of all, let's back up a little bit. There was a fire there. I don't know if you see.
Hold on, let's get to who you are first. Let's not
Okay,
back
go.
up yet.
Okay.
You're the tenant?
I leased the property.
You lease the property. Does somebody from 12
years,
Unico Development, do they know you're here on their behalf today?
I don't know. I was looking for him. He's not here. I don't know. I came because it's the first time I'm in the country. I haven't been here. It was 10,000 miles away. There was a fire on December 17th, I think is when it happened. So this is how this all started. So, I mean, putting a lot of heat on me, it's not cool, actually. I'm a pretty nice guy, and I don't do anything wrong to no one. I got a lot of pictures I never saw in my life. I never even seen the pictures.
Well, no, you don't get the pictures before the hearing. You get the pictures at the hearing. So,
Okay.
but let's start with what do you do for the property? You lease space from Unico?
Correct. It's called KOSS, Kips Outdoor Secure Storage, and we have trucks, cars, boats. whatever someone wants to rent in there. It is C1 property, it's commercial C1, which is the top of the pyramid. And there's a lot of this, I only have 2.5 acres of the 18 acres in there. Oh, well, I mean, the part I'm leasing. But I mean, I've never had any issues in there before, besides the police, West Palm Beach Police not doing their job and allowing people to take things out of my property without paying, which is not good. That's how we eat. But this having a fire and turn around and causing, a bunch of commotion, I mean, that's great. If you ask me, I'll take care of whatever. I've been gone I was in Asia 3 months. And I'm traveling, I do things for children all over the world. So it's not every day that I come here because I have a lot of nonprofits. So I am here now. And I was trying to talk to him earlier. I don't know who he is. I don't know Brad. I don't know anyone. All I got was a couple papers sent to some people that were on my property at the time. But I mean, I got yelled at a lot, which I don't like at all. So I like to have respect. And the respect now is the first time I spoke with him. I don't even know his name. I thought he was Ryan, the guy who was talking to me. So whatever needs, 90% of it's already cleaned up. I mean, I don't know why no one's had any conversation with me, but I did speak with Brad from code enforcement, and we've had 3 or 4 dumpsters in there, cleared the fire. If you want to see pictures, they're in my phone. And it was sent to Brad, so it's not like they don't have it. I don't know why someone's not presenting it here today and showing how much has been done.
Magistrate?
Go ahead.
To interject, I've been to the property at least 3 other times when the post did. One for the pre-hearing inspection, and every time I go there, the gate is closed. I can't go past the gate.
Right.
I'm not allowed to go past the gate.
Right.
So if no one's there to accompany me, how can I confirm that anything's been done there?
And since this happened, FPL shut our power off, so we don't have power there. So all these things now, all the cameras are gone. There's no cameras in there for any security at all. So that's the reason why the gate is shut. If you got millions of dollars worth of property in there, someone's property, and it's my job to watch over it, I'm going to watch over it the best I can. And that's what I'm doing until something changes and I get my power back on. Right now, everything's disconnected all over the place so that I can have power like I did when I first started in there 11, 12 years ago. And I would like to respect back, because I've cleared the property. Whatever other things you told me today was the first time I've heard it in my life. So I'm willing to do whatever I have to do to make it correct. I have lots of properties all over the United States, all over the world, and I've never been approached like you approached me today. It was very uncool. If you haven't been there, if you want to see the pictures, you can see where the fire was, everything cleaned up, and everything you said that was in violation. The pictures you showed there, none of that stuff's even there anymore.
Sir, we can schedule a re-inspection date. That's why we're having a hearing.
You could have called me.
I don't know who you are.
Same phone, 40 years.
We can schedule a re-inspection date. That's why we're having a hearing, so you have time to get all that stuff rectified.
Well, I can show you Ryan's number. Me and Ryan have been talking many times. I was in a hospital for 7 days with cellulitis. Then I went to Georgia to my property up there because I have lots of stuff going on. I have chicken farms up there. So I need to take care of my business. I come back here, but no one's met me. No one's called me, and I've called both of you, everyone.
All right, so do you have a business tax receipt for your business with the city?
Excuse me?
Do you have a business tax receipt for your business with
No,
the
that's
city?
what I do need to get that.
Okay, so that won't change based on the photographs in your phone. So you need to get that application in. Are those RVs that are on the property, is that part of the space that you lease?
There's some RVs that are on their property, of course. But the ones that was there, got burnt down. That's what happened. It was burnt when it was just sitting there, storage. The other ones are already, everything they said, I spoke with Brad. He told me what I needed to do.
Who's Brad?
I did everything.
Let me interrupt you. Who's Brad?
Let me interject, Magistrate. Like I said, I visited the property with building, fire, police. So he has cases with building, fire, and police. It's
Is
not
Brad
just
in
me.
code enforcement or no?
His name is Ryan.
His name is
one of the
Ryan.
building
Ryan.
inspectors.
Okay.
Sorry. Because he told me to start sending things to the email address, which I started to do. So I don't even have those pictures in there to show how clean. Like there's a dumpster. I don't know. That picture must be. If that's.
Well, I don't think we're here for cleanliness, right? That's not the issue. The issue is people living in the RVs and the business
I need evidence
tax.
that there's no people living in the RVs or the trailers. I need evidence that it's been cleaned up. Basically, I need to walk the property with him.
Okay.
So that's what needs to happen for that portion of it. And he needs to obtain business tax receipt for whatever business he's doing there. And whatever other businesses that are operating out of that location also need one too.
Right. Have you, Mr. McFarland, have you had any communication with Unico Development?
No, ma'am.
Okay.
But I'm here because I wasn't here. I was 10,000 miles away, my home, okay? And just someone to push you, like he's been pushing just here. I've only met him a little while ago. I don't even know who he is. Ryan or Brad, very nice guy.
I've
But
heard that.
I have
I
a-
hear
I have-
you.
But I have a right to live my life.
Well, you
And I've been
do.
trying, I did everything I was supposed to do. Today, I took pictures this morning.
Well,
If you
you-
want to see them, but I mean.
You
it's-
have a business tax receipt, so you haven't done everything you need to do. You need to get a business tax receipt
do,
from
I
the
do,
city.
yes, thank
So
you.
don't tell me that you've done
No,
everything that you needed to
I
do,
didn't-
because that's
I-
not accurate,
I
sir.
never saw any paper was ever sent to me, so I didn't know what was needed.
Okay, well, that's the purpose of the hearing today. So the notice of violation that was posted to the property that you must have gotten a copy of because you showed up here.
No,
so
I saw that with someone put something on the gate, and that's what I saw.
That's exactly what I'm talking about, the notice of violation. So that lists on there exactly what you need to do. You
But I
see
didn't
this?
see the whole thing. I only saw the top and,
Okay, well, there's only so much that the city can do. They can post a notice, it has the code section. So what the purpose of today's hearing is the city is telling you what you need to do.
okay.
You need to get a business tax receipt with the city,
Well,
okay?
I mean, you're talking about, is there something actually in paper that I have that I can actually have that's just, I walk out here saying, okay, these
You're
things I
gonna
need
get
to do, I
an
check
order
off?
after today's hearing, yes, you will get an order. I don't know if you're gonna get it because you're not the property owner. So the property owner's gonna get it. You can request a copy from the city. I'm sure he'd be happy to provide you with a copy of it,
Okay.
but, there will be an order issued for the site. Now, you can also get it from your landlord, the person that you're renting from,
Correct.
right? They're gonna get the paperwork from the city. But either way, you're being put on notice today that you need to get a business tax receipt for the business that you just testified to running on this property, okay?
Okay,
You need to also schedule, you've indicated that you will, schedule an appointment with the code officer so that he can come do the inspection and confirm that what you're saying is correct, okay?
now I met him. Pictures speak 1,000 words.
That's right. So I would ask you to schedule with him, and that way he can come verify that what you're telling him is, and what you're saying here is correct. He has to do an inspection to verify all of that. I don't think there's any reason why you can't get a business tax receipt in 30 days, but you need to get that process started as soon as you
Well,
can,
but I don't
okay?
know, please, I was sick in the hospital. I haven't been doing well, and I have lots going on up north in Georgia. And just, I'd rather have longer than less time, okay? 60 days if you, I'll do whatever I gotta do. He tells me where I gotta go, I'll do it, take care of it. But so far, I've been a lot of pushing, and I haven't had a chance to even see anything about anything.
The trouble is, you cited this in January, right? So you're already almost 2 months into the process?
Yes,
The
ma'am.
fire happened in December.
Okay,
That's how it
so
started.
even that's 3 months. So
I just got back in the country.
I understand that, but those are your choices, not the city's choices. So I understand that. 30 days is plenty of time for you to get a business tax receipt. It's a paperwork process, and you pay the fee. That's more than a reasonable amount of time for you to get that done. Anything else you'd like me to hear, sir?
Just that, I don't know, what was the timing on having everything else done? There was this list of stuff that he wanted.
30 days.
I told him that the one was an office, it was not it was done by a licensed electrician to put the power to the office. And I told him I'm not even, I don't know, I didn't talk to you, I talked to someone else. I don't even know who I'm talking to anymore. But he is not the same person I've been speaking with. But the guy I did speak with said, Scott, I told him everything's coming out of there, that's gonna be taken to Georgia. I have 100 acres up there, everything's leaving that I own, it's in that property.
Okay.
So everything is disconnected, and as you could have seen today, if you've seen the pictures, and, I'm moving forward, without anyone telling me anything. I haven't got any information from anyone, but I know whatever
So the best
happened.
thing for you, sir, is to schedule the inspection, have the code officer come out there and verify that everything is gone.
Okay.
Get the stuff gone that's not supposed to be there. The trailers that have the connections to the water and electric, have those removed so that he can come out and inspect them and confirm that they're gone. Do the paperwork process of getting the business tax receipt, and then you're out of this process.
Correct.
The problem is that you're only so many acres of the 18 acres, right? So there's other things going on the property that are also being captured by the order that I'm going to give
Exactly.
today. So all you can do is control the portion that you're responsible for. If that's just your 2.5 acres, do what you need to do. Call Mr. McFarland, have him come out and do the inspection, get your business tax receipt, and then you're done. Okay?
Yeah, and there was some of the pictures there, and there was like garbage all over. We buy and sell things, and people don't pay, we sell it, and it was
Sure.
a bus full of junk.
Right.
It was on the ground, that's already been picked up and gone.
So, and he'll confirm that on his reinspection. When you allow him inside the gate and when he can see all that, he'll confirm what's there and what's not there, okay?
Yes.
All right. Any objection to the documents that you're seeing on the screen being entered into the record?
The pictures?
Yeah, and the notice documents for
Pictures,
today's hearing?
No, they are what they are.
Okay.
Everything's been already cleaned up.
Okay. All right, anything further from the city?
No, ma'am.
All right, in case CEBLD 231104664, I'll enter the city's evidentiary case files composite exhibit 1 without objection. I'll find based on the certified mail having been delivered that the city had good service for today's hearing. I'll find based on the photographs in the case file and the testimony of the code enforcement officer that the respondent's in violation of sections 82-144, 94-6, and 94-272. I'll require for 94-6 and 94-272, I'll require compliance with those code sections within 30 days, or a $150 fine will be assessed for each day that the violation continues. For code section 82-144, which is the business tax receipt, I'll require respondent to comply within 30 days, or a one-time fee of $250, one-time fine, I'm sorry, of $250 will be assessed. So get your business tax receipt in. There are probably other business tax receipts that need to be applied for, but get yours in so you don't get the one-time fine, okay?
Can things be sent to the address, my address, to my name, to that?
They're required by law, the city's required by law to send them to the property owner
Oh,
and to the
okay.
address listed on the property appraiser and the tax collector's website. So
Because it would have been nice to have someone's name, number I could have talked to, because
So you now have met the code officer, so now you can be in touch
Yeah.
with him, but they're required by law to send it to the addresses on the files with the county's tax collector and property appraiser. I'm sure he'll give you a courtesy copy if you ask him after the hearing, okay?
thank you.
Good luck to you, sir.
That concludes the contested cases. Case number 2, CE 25013298. There is no case address listed.
Good morning, John Frosco, West Palm Beach Code. Case CE 25013298, South Congress Ave, parcel number 7443432000 0007010. This property was cited for no business tax receipt for commercial storage. The notice of violation, notice of hearing was sent out regular mail and certified mail on January 31st of 2025, and the City Hall was posted and the property was posted January 30th of 2025. The certified mail was received on February 3rd of 2025. I have been in touch with the owners of the property, which is FPL. They have different departments, they assign different things. I've gone back and forth and explained what the requirements are. I've even spoke to one of the workers for the flex for the storage company, and they have not done anything. There has been no application for a business tax receipt. The city is requesting 30 days to comply, or the one-time fine of $250. There's this type of business doesn't require a certificate of use.
It does not?
It does not.
Okay. And the business that you're alleging is the operation of the storage, is there,
Right.
that company, that flex company is leasing the space for storage?
Yes, they are.
Okay. And you've spoken with them and they've confirmed that?
I've spoken with, he didn't give me his name, he was an employee of that, and I handed him my business card and I asked them to call me.
Okay.
And I did not, and I spoke to FPL, two separate people in FPL, and, they've admitted that it's a tenant, and they'll get on their tenant to do it, and we haven't got anything.
Okay. And for the record, nobody's here for this case? All right. let the
sorry?
record- I was just confirming that nobody's here for this case. All right, anything further?
Pardon me?
Anything further?
No, ma'am.
Okay. Let me just look at the rest of the file. Can I see that affidavit of posting? Thank you. There it is.
Just for the record, Magistrate, when you were viewing those other pictures, there was a separate case written for the
For the
grounds
tires
maintenance,
and
which
the-
they did
okay.
comply with.
Okay, so that's not at issue now?
No, ma'am.
Okay. Okay, perfect, thank you. All right, in case CE 25013298, I'll enter the city's evidentiary case files composite exhibit 1 without objection. I'll find based on the affidavit of posting as well as the delivery confirmation on the certified mail that the city had good service for today's hearing. I'll find based on the testimony of the code enforcement officer as well as the evidentiary case file that the respondent's in violation of section 82144. And I'll require a respondent to comply with that section within 30 days or a one-time fine in the amount of $250 will be assessed.
Thank you.
Case number 3, CE 24123071, case address 627 48th Street.
Good morning, Jesus Mendiola, City of West Palm Beach Code Enforcement. This case was originally by Mr. Robert Watkins. The property 627 48th Street. Violations were founded on December 11th, 2024. The violations discovered were 78-6. The address characters need to be painted. 18-106A, clean and sanitary. 74-34-A-1-H, trash can in public view. 94-6, unpermitted use. There are 2 units. It's only been approved for 1 unit for rental. 94-71-C. The property was cited on 12/13/2024. Certified and regular mail was sent on 12/13/2024. It was signed for. The notice of violation was posted by Mr. Robert Watkins at the city and property on 12/17/2024. He did complete an affidavit of posting. The photographs taken accurately and truthfully depict the violations I observed when I did the reinspection. I have had no contact with the property. As of yesterday, the property is still in violation of 74-34-A-1-H, 78-6, 94-6. The city is asking for 60 days to gain compliance or $250 a day until compliance is achieved.
So they complied with 9471C,
Mm-hmm.
and they complied with 18106A.
Correct.
So 3 violations remain. Is that right? 78-6, 74-34A1H, and 94-6?
Correct.
Okay. All right, anything further from the city? Anything
Nope.
further?
Nope.
Okay. For the record, is the respondent present?
No.
Seeing none, I presume you want your evidentiary case file in, Mr. City Attorney?
Yes, ma'am.
Okay. All right, in case CE 241-23071, I'll enter the city's evidentiary case file as Composite Exhibit 1 without objection. If I could see the affidavit of posting, I think I missed it. Thank you. I'll find, based on the documents in the case file, the notice documents, which include the certified mail having been signed for, as well as an affidavit of posting, that the city had good service for today's hearing. I'll find, based on the photographs in the case file, as well as the testimony of the code enforcement officer, that the respondents are in violation of section 78-6, 74-34A1H, and 94-6, and I'll require a respondent to comply within 60 days, or 25 or 250?
250.
250, I thought I wrote that down. Comply within 60 days, or a $250 a day fine will be assessed for each day that the violations continue.
Case number 4, CE 24113016, case address 5501 Broadway.
Good morning, Jesus Mendiola, City of West Palm Beach Code Enforcement Officer. This was discovered by Mr. Robert Watkins on 11/19/2024. The violations discovered were 18-106A, clean sanitary, and 18-105-A, non-residential, which needed to be the ceiling fixed inside the store. The property was cited on 11/20/2024. Certified and regular mail were sent 11/21/2024. It was returned. The notice of violation was posted at the property and City Hall on 11/22/2024 by Mr. Robert Watkins. It was actually hand-delivered. He did complete an affidavit of posting. The photographs taken accurately and truthfully depict the violations I observed when I did the reinspection. I have no contact with the property, just the tenant, the owner at the store. As of yesterday, the property is still in violation of 18-106A and 18-105A. The city is asking for 60 days to gain compliance, or $300 a day until compliance is achieved.
What was the fine amount, 200?
300.
300.
according to the store owner, they did replace the ceiling, but due to the owner not repairing a roof leak, the ceiling ended up getting damaged again when it was raining. And there were other violations that were resolved as well after my inspection.
Thank you, sir. Do you believe 60 days is a reasonable amount of time for the property owner to come in compliance for these violations?
Correct.
And thank you. Special Magistrate, the city would like to enter the case file, including the photos and testimony, into evidence, barring any objection.
Okay. What's the clean and sanitary violation?
Consent is like inside the store where they have like the debris falling off.
So it's,
And,
it's only inside, not outside?
Is outside, there wasn't really anything left, but it's still left inside the store. That, which resolving the issue with the ceiling should,
Okay, I just want to make sure there wasn't anything outside. It looked pretty clean outside.
yeah,
Okay.
outside was clean. There's still some of the things where it was damaged before, like on the freezer and all that was cleaned up, but still with some damage from the ceiling, it's still falling down on the floor.
Sure, okay. All right, for the record, the respondent is not present. All right, in case CE 24113016, I'll enter the city's evidentiary case files composite exhibit 1 without objection. I'll find based on the notice documents in the case file, which include an affidavit of posting, that the city had good service for today's hearing. I'll find based on the photographs in the case file as well as the testimony of city staff that the respondent's in violation of sections 18106A and 18105A, and I'll require respondent to comply within 60 days or a $300 a day fine will be assessed for each day that the violations continue thereafter.
Case number 5, CE 25013225, case address 701 South Olive Avenue, 1027.
Good morning once again. Kevin Levine, City of West Palm Code. Properly located at 701 South Olive Avenue, was cited for not having a rental license and certificate of use in violation of City Codes 22-441 and 22-32A. On January 21, 2025, a notice of violation identifying the violations and my contact information and notice of this hearing was issued to the property owner. The notice of violation was sent regular mail and certified mail on January 21st, 2025. Both City Hall and the property was posted on January 22nd, 2025. And the completed affidavit is posted in the case file. The certified mail for this particular unit was returned on February 21st, 2025. However, on January 27th, 2025, I received a phone call from the property owner, and during the conversation, I emailed them a rental license application and guided them as to how to complete the process. He did apply for the rental license and paid the fees, but since then I have not heard from him. The only thing that's required right now is for him to go through the inspection, complete the inspection successfully. So the city is requesting 30 days to come into compliance or $200 a day thereafter.
Thank you, sir. Special Magistrate, the city would like to enter the case file, include the photos and testimony into evidence, barring any objection.
All right, for the record, the respondent is not present. In case CE 25013225, I'll enter the city's evidentiary case files composite 1 without objection. Just a question, what evidence do you have that they're renting? You spoke to them?
Spoke to the tenant.
You spoke to the tenant, he confirmed?
Spoke to the tenant on last Friday.
Okay. And is this a residential unit?
This is a condo.
It's a condo?
Yes.
Okay. All right, I've entered the case file. Based on the affidavit of posting, I'll find that the city had good service for today's hearing. Based on the documents in the case file, as well as the testimony of the code officer, I'll find respondents in violation of section 22-32A and 22-441, and I'll require respondent to comply with those sections within 30 days, or a $200 a day fine will be assessed for each day that the violations continue.
Thank you.
Case number 10, CE 2502-3362, case address 2247 Palm Beach Lakes Boulevard, 107.
Good morning, City of West Palm Beach Code Compliance Officer Paul McFarland. On February 4th, the property at 2247 Palm Beach Lakes Boulevard, Unit 107, was cited for business tax receipt violation. This is a renewal for Trojan, PA. The business as well as City Hall was posted February 20th. Certified mail was sent February 6th. Certified mail was signed for February 27th. I have been in contact with the business owner. The business has since come into compliance. The compliance date was set for February 18th. Violations were not complied until March 3rd. With that being said, city's requesting a finding of fact in regards to the business tax receipt.
Thank you, sir. Special Magistrate, the city would like to enter the case file, including the photos and testimony into evidence, barring any objection.
I also wanted to interject, I did make contact with the business owner this morning, highlighting what was going to take place today as well.
Okay, thank you. All right, for the record, the respondent is not present. In case CE 2502-3362, I'll enter the city's evidentiary case files composite exhibit 1 without objection. I'll find, based on the notice documents in the case file, which include an affidavit of posting, that the city had good service for today's hearing. I'll find, based on the testimony of the code enforcement officer, as well as the documents in the case file, that respondents were in violation of sections 82/144, but has since come into compliance, but not by the required compliance date of February 28th. noting that they did come into compliance on March 3rd. So with that, I will sign a finding of fact.
Thank you.
Case number 16, CE 25013314, case address 5321 Parker Avenue.
Good morning, City of West Palm Beach Code Enforcement, Richard Pasmino. This property was cited on January 30th, 2025. Certified mail was sent out January 31st, 2025. It was signed and received on February 5th, 2025. In addition, the property and City Hall were both posted by myself on February 3rd, 2025. Affidavit of posting is completed and attached to this case, where it indicates it was also sent via regular mail. This property was cited in response to me patrolling my area and noticing the violations over several days. The property was cited for trash can stored in public view, outdoor storage, fence repair required, excessive growth, and unsanitary conditions, including trash and debris. I've had no contact regarding this case. The only code violation that has complied was 9471C for outdoor storage. All other violations remain. At this time, the city is recommending 21 additional days to comply the violations, or we're asking for a fine of $100 a day.
Thank you, sir. And do you believe 21 days is a reasonable amount of time for the property owner to come into compliance for these violations?
Yes.
Special Magistrate, the city would like to enter the case file, including the photos and testimony into evidence, barring any objection.
Can you show me the photos again? Can you walk me through the trash can is pretty clear, but and the fence is pretty clear, but the excessive growth, can you show me where you're talking about?
So it's the vegetation along the fence, along the front of the building, along the sidewalks. It looks like they cut up some of the vines that were growing along the fence.
So on that fence there?
Yeah, but it's incomplete.
Okay.
Those dead weeds.
And that photo's
along,
current from
yes,
the
that's
day before
from
yesterday?
Monday.
Okay. Okay. Okay.
It looks like they repaired that gate right there, but there's still an additional gate behind that blue van.
Okay, no,
The
so
side
the
yard,
portion
yeah.
of the fence or gate is still in disrepair?
Yes.
Okay. All right, in case CE 25013314, for the record, the respondent is not present. I'll enter the city's evidentiary case file as composite exhibit 1 without objection. I'll find based on the affidavit of posting as well as the signed certified mail that the city had good service for today's hearing. I'll find based on the photographs in the case file as well as the testimony of the code enforcement officer that the respondent's in violation of section 7434A1H, 94302A4, 18106B, and 18106A. And I'll require respondents to comply with those code sections within 21 days, or a $100 a day fine will be assessed for each day that the violations continue.
Case number 17, CE 25013282, case address 5612 South Dixie Highway has complied. Case number 18, CE 25013208, case address 735 Selkirk Street.
Richard Pasmino for the City of West Palm Beach Code Enforcement. This property was cited for unpaved parking, rental license, and certificate of use required. And this case was a result of neighborhood complaints and communication with the owner regarding a prior case. This property was cited on January 16th, 2025. Certified mail was sent January 16th. It was returned. But in addition, the property and City Hall were both posted by myself on January 16th, 2025. The affidavit of posting is completed and attached in the case file, where it's also indicated that it was sent via regular mail. Like I said, this property was a result of communicating with the owner, who admitted that she is renting the property. I gave her time to apply. She did not apply, so I created the case. Since creation of the case, she applied for a rental license, which failed by zoning due to the fact that the property is only allowed a single-family home, but it's being used, and she applied for 2 units. I did my interior inspection, which resulted in the discovery of illegal conversions and additions at the property. So at this time, the code sections 2232A and 22441 would not be enforceable, since she will not be able to get a license. A future code case will have to be cited for unpermitted use of land. I just wanted to bring it up since it was cited.
Okay, but
And
you're
it is being
removing-
used for rental still.
Okay.
It just would never be allowed in the current condition. It will be, but she will have to convert it. It was referred to the building department, so she's gonna have to make quite a adjustment with permits.
But you can proceed then, if she can actually get a rental license for the 1 unit, you can proceed with, I'm comfortable with proceeding with that violation. 'Cause
Okay.
she can do it, she just has to make the property compliant before
Okay.
you approve it.
With the other violation, the unpaved parking, the neighbors are constantly calling. It seems like they're doing it, after normal business hours and during the weekend. I was able to show it on the scheduled reinspection date, which was February 21st. The neighbor called, let me know, and I swung by and got a photo of it actually being done. With that violation, I would like to request 5 days, since it is a transient violation, 5 days to comply, or a fine of $100 a day. With regards to the rental license violation, that one, it's gonna need more time. She's not gonna comply within, reasonable time. But she was made aware of everything. She is out of the country, but the city's gonna ask for 60 days for that, or a fine of $250 a day.
And that's for the COU as well, right?
Yeah, for rental license and COU.
Okay.
Reasonable amount of time for the property owner to come in compliance for those violations?
I do, if she's proactive.
Understood. Special Magistrate, the city would like to enter the case file, including the photos and testimony and evidence, barring any objection.
And you cited her, you said on January 16th, right? So you're almost 2 months into when she was put on notice of these issues?
That's when I created my case, but I've been in contact with her since, I want to say end of December.
And even before that, so end of December? Okay. And did you tell her about the 5 days that you were asking for on the parking?
The parking, yes, it seems like she only comes once a month to collect the rent. I discussed her other things that weren't on this case, like the rent, things that the tenants are creating. She did fix a couple, but her not being there, no one really enforcing it, it's going on nonstop.
And I saw an email, there was an email in there. Is that from her to you, or is that from the neighbor complainants? I guess my point is, do you have a way to email her the notice? I don't mind giving you the 5 days on the short transient violation, but I just want to make sure that she gets a copy of it so that she knows the 5 days.
No, that's from the complainant, including some of the parking pictures she provided. So it was an issue of me getting the actual photos myself to
Yeah.
testify, but I was able to get it.
Okay.
Yeah.
Do you normally just send the orders from these hearings just certified mail? You don't post them, or do you post them?
The orders?
Yeah.
No, I don't post them, but I'll let her know.
Yeah,
I
just
have
make sure,
contact,
as a
yeah.
courtesy, just make sure that she gets it. Again, if you told her about the 5 days, I'm comfortable
Yeah.
with that. But sometimes the certified mail doesn't get there in 5 days. All right, anything further?
No, nothing further.
Okay, thank you. For the record, in case CE 2501-3208, the respondent is not present. I'll enter the city's evidentiary case files composite exhibit 1 without objection. I'll find based on the affidavit of posting as well as the signed certified mail that the city had good service for today's hearing. I'll find based on the photographs in the case file and the testimony of the code enforcement officer that the respondent's in violation of sections 94-482A, 2232A, 22441. For code section 94-482A, I'll require a respondent to comply within 5 days, or a $100 a day fine will be assessed for each day that the violation continues thereafter. And for the violations of section 2232A and 22441, I'll require a respondent to comply within 60 days, or a $250 a day fine will be assessed for each day that those violations continue thereafter.
Case number 19, CE 25013294, case address 1022 Green Street.
Richard Pasmino for City of West Palm Beach Code Enforcement. This property was a result of delinquent rental license. In research, seems like the property sold and a new owner is renting the property now. So this code case is for the new owner to obtain a rental license and certificate of use. The code sections are 2232A and 22441. The property was cited on January 29th. Certified mail was sent out January 31st. It was received and signed by someone on February 11th. In addition, the property and City Hall were both posted on February 3rd by myself. The affidavit of posting is completed and attached in the case file. I have had no contact regarding this case. The emails that were before us is with the utilities department here to confirm that the property is being rented and occupied. The 2 units at the property have names other than the owner's name, and I was told that one of the account owners has had the account since 2014 through multiple property owners. At this time, the city's recommending 21 days to obtain the rental license and certificate of use under the current owner, or we're asking for a fine of $100 a day.
Thank you, sir. And do you believe 21 days is a reasonable amount of time for the property owner to come in compliance for this violation?
Yes.
Thank you. Special Magistrate, the city would like to enter the case file, including the photos and testimony and the evidence barring any objection.
And what's the evidence that you have that they're renting?
That it's currently being occupied. The water account is
Okay.
active, and it's in 2 different names. Since it's a duplex, it has 2 separate accounts. And the supervisor over at Utilities told me that one of the accounts was established and is current since 2014 through previous and multiple ownerships.
Okay.
And the previous owner did have a rental license that was closed
Yeah,
out
okay.
since they sold.
Okay. And you could tell from the outside that it's 2 units?
Yeah, multiple properties on that street are the same layout.
Okay.
Yeah, they're all duplexes.
Okay. All right, I saw the affidavit. All right, in case CE 2501-3294, I'll enter the city's evidentiary case files composite exhibit 1 without objection. I'll find based on the notice documents in the case file, which include the certified mail having been signed for and an affidavit of posting, that the city had good service for today's hearing. I'll find based on the testimony of the code enforcement officer as well as the documents in the case file that the respondent's in violation of sections 2232A and 22441. I'll require respondents to comply with those code sections within 21 days, or $100 a day fine will be assessed for each day that the violations continue thereafter.
Thank you.
Thank you.
That concludes the regular cases. We do have one police case. Do you want to call that one now?
Is that set for a time certain?
I think it was set for 11, if I'm...
Okay.
Yeah. Yeah, item number 25.
Yeah, could we do that for just a brief recess for 5 minutes, and then we'll reconvene? All right, with that, I'll reconvene the City of West Palm Beach Code Enforcement hearing, the other matters section. It's 11:08. This part of the proceeding, I guess what I'll do first is give a few introductory notes and swear anybody in who's going to be testifying. You said this was 25, right?
Correct, case number 25.
All right, so first, what I'm going to do is swear anybody in who's here to testify on any of these items on this other matters section of the agenda. So if you're here, if you could raise your right hand. Anybody speaking, I guess, on item 25 at this time? I'll swear you guys in. Not this item. Just remind me on when we get to your portion to swear you in as well. Raise your right hands for me. Do you all swear affirm to tell the truth, the whole truth, and nothing but the truth? Yes, ma'am. Thank you very much. And this one, I presume, will proceed in the same fashion. The city will put on its case first. And again, I'm sorry, I should have mentioned for those who were not here on the previous section of the agenda, my name is Amity Barnard, the special magistrate for today's hearing. I presume this will proceed in the same manner as the last agenda, where the city will put on its evidence first, call the witnesses that it intends to call from the podium to my left, and anybody here on behalf of respondents will appear at the podium on my right. Both sides will present their evidence, their testimony, any witnesses, and then at the end of that, I'll make a final ruling on the case, which will be either provided as you leave here or in the mail after the hearing. So with that, I'll turn it to the city to call its case.
Case number 25, PD 25020442, case address 3111 45th Street, 7.
Thank you. The city would like to call Officer Tran and Officer Carballo to testify on this matter. We can start with Officer Carballo because I believe you were the officer that issued the first written warning. And if you could just tell us what you know about this case and your involvement.
Good morning.
Start with your full name for me, just so I have it.
Yes, ma'am.
Thank you.
My name is Christian D. Caraballo Padilla, Officer ID number 2203 of the West Palm Beach Police Department.
Thank you, sir. Go ahead.
Yes, ma'am. On December 2nd of 2024, at approximately 1:39 hours in the morning, I was conducted what we call directed patrols in the area of the plaza located at 3111 45th Street. After the department had been flooded with overwhelming complaints of loud music coming from the Empire Lounge located at the same address. On that day, I was conducting my patrol sitting right across, like right in front of the building located at 3115 45th Street, which is in the same plaza.
Okay.
It's called Got Resources Incorporated. From there, the music was clearly and plainly audible. I initiated contact with management. On that day, I spoke to Daley Blake, black male, his date of birth of 6/7/71. He identified himself as the manager for Empire Lounge. We went over to City Ordinance 34-36 and issued him a written warning for the violation.
Thank you, sir. And we can now ask for questions, and you can hang tight because the attorney for the other side might have some questions for you. Now I'd like to ask some questions for Officer Tran.
Officer Tran, ID 2180 with West Palm Beach PD.
And what's your first name?
Tony.
Thank you. Go ahead.
And Officer Tran, you can do the same as officer before you. If you could just tell us about your involvement in this matter, the day that you showed up, what you observed, and everything you know about this matter.
Yes, sir. On December 6th, I was working the zone area of Empire. I did direct patrol there. I was sitting in the parking lot along 45th Street. That night, we've been getting a couple complaints from residents off of the North Shaker area, off of Village. So I made contact with the business and try and work with the business owners. Hey, the music's too loud. Per the city ordinance 3-36, music can't be over 25 feet from the music source. So gave them warnings throughout the night, verbal warnings. It was to a point there where other complaints had come in, my hands are tied, so I noticed that Officer Carvalho had read a written warning on December 2nd. Therefore, I did a first violation of $500 fine for a north violation.
Thank you, officer. And just for clarity, based on your personal observations, was this an unreasonably loud noise disturbance?
You can hear it across the street, so I would say yes.
And based on your observations, was the noise plainly audible at a distance of 25 feet or greater?
Yes, sir.
Thank you, sir. The city has no further questions, but the witnesses might want to hang tight because I believe there might be some questions asked of you.
All right, does the city have any additional witnesses?
No, special magistrate.
I guess, is this paper copy, this is for this case, correct? Okay. And this is, I presume, the same documentation that's been scrolling on the screen? Okay. What is the city seeking today in terms of remedy?
The city is seeking enforcement, or we're seeking the fine of $500 for the violation.
And do you have any additional testimony as it relates to service? This was a citation issued.
So, Officer Tran, you issued the citation directly to the individual listed on the citation.
Of Empire, yes, sir.
No further testimony other than Officer Tran's testimony.
Okay. Who's here for this case? Can you come to the podium on my right? Come to the podium down here on my right, ma'am. Good morning. Your name?
Olin McLean, on behalf of Blake ST Plaza.
Spell your last name for me.
Capital MC, capital Lean.
And are you counsel?
Yes.
Okay. All right. Let's do the documents first, I guess. Are there any other, do you need to scroll through any other documents on the screen? What are the three again? I guess, can you pop them up there again? Is this citation, keep going? Okay. Okay, that's everything that I have here. All right, go ahead, ma'am.
Okay. I'll start with questioning the first officer, Carvalho.
Okay, go ahead, thank you.
Yes, ma'am.
Okay, so pursuant to the ordinance 3436 that's cited in the citation, it provides that you are to provide 15 minutes to the individual upon issuance of the citation. Did you do that?
That is correct.
Did you give
15 minutes to turn it down?
Correct.
They did turn it down after 15 minutes
Okay, and
with initial warning.
okay, and what is the decimal reading at that time when he turned it down?
It's outside of the downtown development area, so we do not conduct decibel readings out there.
Okay, so if my client turns it down and pursuant to the citation, it states that it was music and bass speakers, how is my client to know that they are to comply if you do not provide a decimal reading?
You repeat the question, counsel?
The decimal reading, pursuant to the statute, it does provide a decimal reading. So I'm trying to determine whether or not you are aware of the decimal reading that needs to be provided in their area.
Per the ordinance, we do not need a decibel reader. It has to be plainly and clearly audible. That's enough for me to write a warning.
Okay. Plain and audible. Pursuant to legislative requirements, the standard is a minimum of 65. Outside of that, the downtown district, it's at 85 at its height, and that's from 12 to 1 o'clock. Between the hours of 1 to 2 for downtown, let's see. It is 65 decimal reading. So again, I'm trying to determine how you actually make the determination that my clients was outside of the requirements of the city ordinance. If you do not use any decimal meters, how are you to know that they have actually complied?
Yes, council. I have outlined the city ordinance right here. Okay. Section 36-36 of the noise ordinance. Section 8(1)K, whether the noise is plainly audible at a distance of 25 feet from the source. It does not specify that we are to use decibel readers for issuing citations out of the downtown area.
Can you repeat that again?
Yes, ma'am. So section, city ordinance 36-36, 34-36, my apologies, noise disturbance prohibited. Section 8(1)K, whether the noise is plainly audible at a distance from 25 feet from the source. Also, the same ordinance in paragraph 9, I believe, it says sound production devices. Section A, on private property, it is prohibited to use or operate or permitted to be played, used, or operated any radio receiving set, television set, musical instrument, phonograph, or other machine or device for the production or reproducing of sound in such manner as to disturb the peace, quiet, and comfort of the neighboring inhabitants. Council, the reason why we got there was multiple noise complaints from the residents near the Empire Lounge.
Any further questions for that witness?
No.
All right, before you move on to the next witness, any redirect on this witness from the city?
Nothing on redirect, Special Magistrate.
Okay. Go ahead, ma'am, with your cross-examination of the second witness.
I essentially just have the same questions for the officer. With respect to the citation, again, did you actually provide time for Mr. Blake to reduce and comply with the statute?
Yes, ma'am. I do, I believe that our officer do have like a good relationship with the business. We try to work with them. So therefore, I did give them the first offense citation based off of Officer Caraballo's warning. I was parked, like I said earlier, I was parked along the 45th Street. We have a certified laser officer that measured the distance from the parking spot that I was parked in to the door was 255 feet from the music source using a certified laser. So yes, after I gave them the citation, I gave them multiple, amount of time to turn down, which they did.
Okay, and how much did they reduce the fine?
To where they didn't get any other citations afterwards, because after 15 minutes, if they didn't turn down, we would have to issue a second offense citation.
Right. Now, have you guys ever issued any noise is this the first time you ever issued any citation for any noise complaints?
No. So we have issued I have issued multiple warning citations to residents, to other business that, are outside of the entertainment district. But with this business, it was my first one. I had to do a first offense.
Right, and this business is actually in a commercial area, so it is deemed commercial.
And I understand it's a commercial, but outside of the entertainment district, which is the downtown and then Northwood downtown, everything else goes off of 25 feet from the music source.
Okay, so that's it for now, Jan.
All right, let me just ask the city if they have any redirect on this witness.
Yeah, just a few questions on redirect. Officer Tran, thanks for your testimony. So your understanding is it your understanding that there are special rules as far as decibel reading would concern to determine a noise violation exists that apply to special entertainment districts?
Yes, sir.
And it's your understanding that those districts, their property is not in one of those districts, correct?
Yes, sir.
So section 34-37 of our code that provides for special decibel reading in special entertainment districts to determine noise violation, that is not applicable in this situation?
No, sir.
Okay. So it's your understanding that there was a warning that was provided a few days prior to you issuing a citation, correct?
Yes, sir.
And then your understanding of the statute is that the first offense after a warning is issued shall be punished by a $500 fine. Is that correct?
Yes, sir.
And one last question is, based on your knowledge, have there been more complaints of noise violation from this property since a complaint was issued, since your fine was issued?
Since the fine has been issued, since December 6th, there has been 7 loud music reported since the citation. On February 23rd, another written warning was issued from another officer.
And one last question, because we addressed the special entertainment district, but and you did address in your testimony, but just for clarity, I just want to bring this up. 3436A that you've cited under here, that determination of a noise disturbance can be based on your personal observation. It can be based on an observation of a noise disturbance occurred. It can be heard from the source over 25 feet away. And those are some circumstances in which a noise, that can be factors that can be included in your determination of a noise violation that exists. But that's not an exhaustive list, is that correct?
No.
Thank you, sir. Nothing further for this witness. Thank you, Special Magistrate.
Okay, go ahead, ma'am. Any just other testimony you'd like me to hear, or anything else you'd like to say? Do you have any witnesses to call?
I would like to call Delroy Blake to the scene.
Okay.
The
Do me a
owner.
favor. You're very soft-spoken. Pull that microphone a little bit. There you go. Just so I can hear everything you're saying.
I did want to add one more thing. I know where the city ordinance doesn't cover certain areas. Sometimes the state statute does. And I don't have the statute number. I guess I didn't bring it with me, but it does provide for 65 decimal reading in the residential area. It's actually 60. So, and that's why I was asking the question with respect to the decimal reading. So My client has purchased 3 different decimal readers so that they can measure the sound, and they keep those decimal meters or readers, one at the entry point of the lounge, which it is a lounge in a commercial area. They also keep one at the outside back area of the lounge, and they also keep one right off of 45th Street, right near the stoplight, which is at the end of the property line. So I do want to say that, but.
Okay. And you want to call your client as a witness?
Yes, I just had a couple of questions.
Okay. Let me have the officers, you can sit down, but let me have you not leave the hearing in case there's any questions I have for you as we proceed.
Yes, ma'am.
Thank you. And were you sworn in when I swore everybody in, or did you?
No, ma'am,
just-
I wasn't.
Very good. Raise your right hand for me. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
And your name is?
Sean Jackson here on behalf of Blake Street Plaza. I would like to ask, after having had a conversation with Commissioner Warren's staff and Commissioner herself, that if you're planning to make some kind of adjudication on a day, that perhaps we can postpone that and allow for city administration to become involved in this. This seems to be much more granular in detail about specifics that even we are discovering in the course of our own investigation.
Let me just stop you there. Are you counsel as well?
No, I'm not.
Okay, so you represent who?
I'm here on behalf of the Blake Street Plaza.
On behalf of the plaza?
Yes.
Okay. All right, go ahead.
There seems to be some discrepancies that have come about, and I just want to make sure that before those discrepancies are presented before you, that we've had time, efficient time to investigate the findings or the details of those findings. And again, this is not the proper forum to get into it, but I would like to come back before you with those key details. So if you are planning to make some kind of adjudication day, I would request that you postpone it and giving us an opportunity to speak with city administration.
Well, so the code enforcement case has been set for hearing for today, so now is the time. If you have discrepancies and you have any testimony that you want me to hear, now is the time for me to hear that.
Unfortunately, with all due respect, I mean, we just had conversations with the commissioner on Friday and on yesterday, and being the fact that they're out of town right now at Palm Beach County Day in Tallahassee, it's made it a little cumbersome to finish the investigating aspect of this process. But I mean, long or the short, these complaints seem to be coming from some of the same persons, just being repeated under different names, which has brought the unmitigated attention to Blake Street Plaza. As attorney stated a few moments ago, these noise decimal readers, they have been allocated across the entire property itself. And some of these complaints that are coming from as far as Lone Pine Estates, which is, I mean, miles away from this establishment, makes it virtually impossible to be able to hear what the complaint is being purported on. So the reason why I said I would like it postponed to the next hearing is so that way we can come and articulate that evidence before you tangibly and not just based off of hearsay. Okay. But again, this just came to our attention on yesterday.
Okay. All right, thank you, sir. Ms. McLean, did you still want to call your client as a witness? I thought I heard you reference somebody else's name that you wanted to call. You don't have to, but I just wanted to make sure you had an opportunity if you choose to.
If we will be continuing this, then I would appreciate it if I would not call him at this time, but at a later time.
Let me ask the city for a response to the request for continuance.
So the city objects to the continuation request. Ample notice was given, and that could have been lodged before. And at this point, we'd like to pursue adjudication of the $500 fine.
Okay. I'm inclined to find to be amenable to the city's position here. I mean, this citation was issued in December. We're in March, so you've had 3 months to prepare for this hearing. The testimony of the police officers didn't have anything to do with complaints coming from Lone Pine Estates or anywhere else. The testimony that I've heard this morning is specifically from the officer who stated that he was 255 feet from the lounge. So I'm not sure that as it relates to your hearsay argument that any of that has even come up this morning. So I don't see any reason not to proceed this morning. As the city has indicated, they cited your client. This was set for hearing. The parties are here, so please proceed with any additional testimony you have. Okay.
Ma'am, with all due respect, we just started engaging with City Commission on this matter as a result of the new information coming about, and this is of no disrespect whatsoever to the officers who have done a very fine job at doing their job. However, what we have learned is that these complaints have started coming about from persons and communities and neighborhoods that are in no way, shape, or form geographically close to this establishment. So though this citation was offered back in December, was rendered back in December, as we've just started engaging City Commission on this because this is becoming out of hand, to be quite frank. The level of complaints that continue to come in against us, it makes it alludes to there being more of a deeper issue than just the complaint itself. So again, I would like to request that you continue it to the next hearing, just to give us an opportunity to finish engaging. Our district commissioner isn't even in town right now. They're all, again, in Tallahassee. And we would like to get them at the table with city administration to make sure that this is mitigated properly.
Okay. I appreciate that additional testimony. Unfortunately, the city is objecting to that continuance. So city staff is asking me to proceed today. I have one specific date of citation, which goes back to December. Again, that has nothing to do with additional complaint. I'm not here to adjudicate on additional complaints that have come after that date. I'm just here specifically on the case that's before me this morning, which dates back to the December citation. So let me ask Ms. McLean to call any other witnesses that you have at this time.
I call Delroy Blake.
And you were sworn, sir, right?
Yes, ma'am.
All right, your name for the record?
Delroy Blake.
Okay, thank you. Go ahead, ma'am. If you want to question him, go ahead. And do the best you can to both kind of stand at the podium so that the recording picks you up, if you could, for me.
Okay. Restate your name again for the record
Delroy Blake.
and provide your position or your title with respect to the entity.
You gotta get within 4 inches of the mic.
Would the city object if I had the attorney stand at this podium? Ma'am, if you could stand at that podium, that'll help. That way you can be heard and he can be heard at the same time. Thank you, ma'am.
Please provide your title or position with respect to Blake ST Plaza.
Management and owner.
Okay. And at the time in which the first time, actually, could you advise the commission exactly how many tenants are there roughly in the plaza that you manage?
How many tenants at the time?
Yep.
One person, one tenant.
In the whole plaza?
In the whole plaza for the whole night.
Okay. How many suites are in the plaza?
Repeat again?
How many suites are within the plaza?
I think about 16.
Okay, roughly 16. But at the time of the issuance of the citation, you were there to manage the one entity, correct?
Yes.
Okay. During the course of December, were there any evictions that took place at the plaza?
No.
Any notices provided for any tenants that were in default?
No.
Okay. And With respect to the citation that was issued to you from Mr. Carballo, can you advise whether or not time was provided for you to comply with the ordinance?
Repeat again?
Can you advise if he provided time for you to meet the requirements of the statute and the ordinance to bring the volume down?
No.
Okay, so the citation was automatically issued to you?
They just ask for me and tell me that they're gonna give me a warning ticket, and I ask them for my ID, and I give them my ID, and then they give me the ticket, and I go back inside, and then them drive off and stuff like that.
Okay. That's with the first one. Can you advise what happened with the second one, where the actual $500 fine was issued?
Same thing, they just ask for me, and I will go outside and tell me that they're gonna give me a ticket. And I said, for what? And then they say, when the front door opened, the knives come out from the front door. When they went, like, if a person went outside, then the knives come out when the front door open.
Okay, and then again, when you were issued with the 2 citation, what did you do to deal with any future complaints?
I go and I fix the front door and make it more tighter. That's if the knives, they get no knives outside and stuff like that.
Okay, and did you purchase any meters or anything?
Repeat again?
Did you purchase anything to help you measure the sound level?
Correct. Yes.
Okay. Thank you.
Thank you.
I'm going to call one more witness.
All right, let me ask the city to do cross-examination on this witness while he's there, before I release him.
Yeah, just a few questions, if I may.
Go ahead, sir.
So, thank you, sir, for being here and for your testimony. So, is it correct that you were personally issued a warning, and then a few days later you were issued a fine?
Correct.
No further questions for this witness.
Okay, I'll ask you the same as I asked the officers. Please don't leave the room, but you can go back to your seat for now.
Okay.
Thank you. Your name, ma'am?
Shernette Thompson.
And your relation?
Owner
case?
to Empire.
You're the owner of the lounge?
manager.
Okay, thank you. Go ahead.
Okay. Okay. Now, the question, outside of being the owner and manager for Empire, could you advise whether or not there were any evictions or anything going on during the month of December?
Yes.
Okay. How many, approximately?
I would say 2 evictions and one
Okay.
notice.
And with respect to the evictions, do you believe that there were any disgruntled tenants that left the plaza?
Yes.
Just to address the questions that may come up, can you advise, does Delroy generally handle any issues regarding the tenants?
No.
Those are my questions for this witness.
All right, does the city have cross-examination for this witness?
No questions for this witness.
Just one question. So, Mr. Blake just testified that there were some renovations done to the door. Was that done to the door of your lounge?
Yes, ma'am.
Okay, what was done?
We hired a vendor that fixes door to try to have it more stabilized. Because when you go with the exit, it would have two doors open. So they have stabilized one to just have one door open, and in order to trap the noise from coming out.
Okay, so whatever renovation you did was to make the door so that only one door had to open and that it closed faster after people went in or out?
Yes, ma'am.
Okay. Okay, thank you. Nothing further. I'll ask you the same thing if you're finished with her.
I am.
Okay, I'll ask you the same thing. Please don't leave. Just go back to your seat.
Thank you.
Okay. Any other witnesses?
No other witnesses.
Okay. Let me ask you to come back over to this podium, Ms. McLean. And let me ask the officers to approach the podium again here. Just a couple of follow-up questions for you. So, officer, I think this is probably best for Officer Tran. Your testimony was previously that you were sitting 255 feet from the source of the noise. Could you see, explain to me what you could see from that vantage point. You were across the street, I think is what I heard you say before.
No, I'm sitting in the parking lot of 3111 45th Street.
So where in relation to Empire Lounge is that?
It's the fifth parking lot along 45th Street inside the plaza.
Okay, so you were within the plaza, but 255 feet away?
Yes, ma'am.
Okay. And was Empire Lounge visible from where you were sitting?
The front is visible. The main music source where all the complaints are coming from is mainly coming from the patio. They have a closed-off patio where they have music and stuff like that. So the way the building is, an L shape, pretty much. It's facing the south east direction. I am sitting here, if you can see, it's along the 45th Street. So may I come up to you and show this?
Actually, maybe come to right in front of me and just point so that she can see it as well, or show her. I just want to make sure that she sees as well, Ms. McLean. The recording's not going to get you. Just point to what you pointed to. Tell me where you were sitting. Point to where you were sitting on that aerial.
I am sitting along the 45th Street. This is 45th Street right here. The yellow highlight area is in Empire Lounge to include the back patio area.
Okay. Can you see that, Ms. McLean, or do you want him to approach you?
I can see that.
Okay. So let me ask you to go back just so the recording gets you to the microphone. So the patio is in the back there behind that yellow. What you're showing. There's an outdoor patio.
Yes, ma'am.
Okay.
So when music and events are held there, the music is echoing in the back of the building towards the Shaker Way area along to the Riviera military area.
Okay. And this is not an issue of that's what I was trying to get at, is where is this sound emanating from? There's some testimony that a door was fixed in the front to allow to stop the noise coming out, but it's not coming from the front door, it's coming from the rear patio area?
It depends on time of night and time of days.
Okay. Okay, thank you, Mr. Tran, that is helpful. I guess let me just ask the city for a response as it relates to Ms. McLean's argument that there is a state law that applies relative to decibel readings. In this matter, what's the city's response to that?
So the city is here on enforcement of our local ordinance. The city is unaware of a statute that is applicable in this circumstance, but we are here, in this forum on the matter of our code enforcement of our section of our code, section 3436A, which is applicable to this property. And so that's our response to that. And if you would like me to respond to any of the other issues raised, I'm happy to do so.
No, I guess just a clarification, the agenda also lists section 3436B9A, but I haven't heard any testimony about that. Is that at issue here today, or is that not at issue?
That is at issue. These two sections of the ordinance are intertwined. 3436A is essentially that, that there is a noise disturbance, and then the second section that's cited here goes into greater detail of what is enumerated at and what the potential sources of a disturbance could be. So these two are intertwined, but for purposes of today's hearing, I mean, they're cited for a noise disturbance under 3436, which would include A and B9A.
And can you scroll up? Are both of those listed on the citations on the warning that were issued?
If I may, can I make a statement?
Yes, hold on 1 second for me. Let me just check the citation. Yeah, there it is right there.
They're gonna let me re-examine.
No, it just references 3436 generally. Okay, go ahead, Ms. McLean.
I just had a statement to make with respect to the decimal reading. It's just, I understand that there's different readings for downtown district, for like the Clematis area, and there's also a decimal reading for the Northwood area, which happens to be 75. But my thing is, when you have a lounge that is in a commercial area, just because it's not in a central downtown city place, it's questionable as to whether or not you cannot use decimal reading for those commercial areas, especially when it's a lounge in that area. So
Let me have the city respond to that. What's the city's response?
So the city's response to that is that a decibel reading could be probative, but not dispositive. There are a number of factors that are that should be included in the analysis per our code, 3436, which includes the personal observations of the officers, which were testified to today, including that the noise can be heard from 25 feet away from the source. So while I understand that a decibel reading could be helpful, particularly potentially in being able to ascertain vibrations from the noise source, that information can be useful, but it's certainly not dispositive on this issue.
But,
Go ahead.
my response to that is that personal observations can be very subjective and biased, and that's one of the reasons that they actually do have decimal readings. And again, as stated, if I can use a photograph that the officer had showed you, I can show you where the decimal readings that my client had, where they had actually placed them.
I guess, and I'm happy for you to do that. I guess my question is, though, the code section that they have cited you for, 34-36, A says, "It shall be unlawful for any person to create a noise disturbance by making, continuing, or causing to be made or continued any unreasonably loud, excessive, unnecessary, or unusual noise that is plainly audible." So that code section doesn't say noise that is over X decibels. That just says plainly audible. And what I've heard from the officers is one of the factors that is in subpart 1K says whether the noise is plainly audible at a distance of 25 feet from the sound source. So this code section doesn't require the city to prove that there was an excess of any decibel level. It just requires the city to prove to me that there was a plainly audible noise more than 25 feet from the source of the sound. And the testimony that I have is that the police officer was 255 feet from the source of the sound, which is well in excess of 25 feet from the source. And there was what he's telling me is there's plainly audible noise at that distance. So I understand your argument about decibels, but I'm not sure that the code requires anything more than a demonstration of plainly audible sound at a distance more than 25 feet.
Okay, that's a good point, but there's also another perfectly good example is that there's a high school not too far from there. And I can recall, and this is my personal, from my personal observation, that I couldn't understand one night why there was such a loud sound coming from there, but there was a high school band playing. But at that time, no one is issuing the high school a citation, but you have an audible sound that's not as loud as a drum, beat playing at a high school band, but at a lounge whose sound is probably less loud, they can issue a citation. So this is where it comes into question, and this doesn't make any sense. So there should be a decimal reading.
I hear that. I guess my response to the high school band is I'm not here today to speak on whether or not there are not other violations occurring. There may be other code violations occurring from the high school. I don't know whether the city has cited the high school or not. I appreciate that position. That certainly could be true. I have been by many a high school with the band playing, and you can hear, but I don't know where the city is on any other violations. All that's before me today is your case, your client's case.
I really would like to request a continuance because there are other issues, as Mr. Jackson have stated, and it's has to do with the fact that there is no decimal reading, which there should be, especially in a lounge area.
Well, but that's a policy decision. So my job here today is to enforce the code that the city has on the books as of the minute that we're sitting here today. There isn't, as I read the code and as I've heard from the city, the decibel restrictions in 3437 say sound level limit, special entertainment districts, and it says the boundaries of which in subpart A2, boundaries, the area for which this section applies, and then it specifies A through C. That is not, those three locations are not your property. So the code as it is in the Code of Ordinances for the city today, those decibel readings don't apply to your property. Whether they should apply or not, that's a policy decision that can be made. That's not within my purview here today. My job is to look at the facts that are presented by both sides and determine whether there's a violation of the code as it exists today. So as it exists today, there are no requirements for decibel readings as I read section 34-36 in the city's code. I appreciate that argument, but that doesn't preclude me from ruling on the case today. Whether there's a code change in the future, that could happen, but that doesn't change the code as it exists today.
Your Honor, if I may, this establishment has, prior to the current owners, has been a club for the past 20 years. So under the previous owner, and again, this is why continuance would be so imperative at this moment, because I would like to bring the previous owner in who has never had this kind of issue. The officer shortly alluded to shortly ago that the sound is projecting over towards the Military Riviera Beach area, which is going the opposite way of the municipal boundary for this municipality. So for the ordinance 34-36-B-9-A, sound production devices, in such a manner as to disturb the peace, quiet, and comfort of the neighboring inhabitants. There are no neighboring inhabitants that is disturbing because there's no one else on the adjacent side that is within this municipal boundary that could or could not be impacted by the noise that is going on currently. Furthermore, this is why it is imperative that city administration become involved, because this establishment has been zoned. The zoning allows for this type of an establishment to be present, and it is applicable to the zoning that has been here for the past 30 plus years. So now all of a sudden that an issue is arising as it pertains to sound production. Well, this same sound production has consistently been what it is present day for the past 20 years. And the previous owner of that establishment did not have an issue such as this. So again, with all due respect, even though city attorney is objecting to the continuance, there are a lot more granular details that need to be presented to substantiate
But is
this
that
complaint.
true though? I don't mean to interrupt you, but whether or not somebody who operated there for 20 years in the past had the same level of noise coming from whether it's inside or outside doesn't negate the facts of the citations that were issued in this case, correct?
But I think the reason why I brought the second witness up is I believe some of the complaints are coming from a disgruntled tenant that was in the plaza. So,
And I appreciate that, and I figured that's where you were going, but that doesn't change whether or not there was a violation at the time that the officers who are here testifying that there was a violation of the city's code. The origin of the complaint doesn't change whether or not there was a violation, correct?
Correct. To answer your question, the previous owner could testify to the fact that they've never once had a noise ordinance complaint, and they maintain the same setup that is being maintained present day.
I hear that. I don't think that has any bearing on this case. That may have some bearing on whether or not they got away with violating the city's code for however many years, but.
Well, and I think that's where we're arguing apples versus oranges. But if the officers alluding to the fact that the noise is being projected towards the Military Riviera Beach way, and that noise is opposite of the municipal boundary, then it's impossible for anyone being impacted, per what your language in the ordinance says, where it says a comfort of the neighboring inhabitants. There's impossible for any neighboring inhabitants to be impacted by this noise if it's being projected opposite direction of the municipal boundaries.
Right, but that doesn't eliminate the fact that there's testimony from the officer that he was in his car 250 in the same plaza parking lot 255 feet away, right?
Right, and on private property, which begs the question is, well, why was the officer on private property to begin with? Was he requested to go there? Because the owners of the property did not request for the officer to be there. So at that point, the question becomes, well, is this being singled out and targeted for some particular reason, or is it the complaint deriving from a disgruntled person who should not have in any way, shape, or form even bought such a ridiculous accusation? Because for this establishment to be, for the past 20 years, maintaining the exact same regiment and the zoning allowing for that, now for all of a sudden for there to be a complaint arise, and the complaint is counterproductive or counterintuitive, I should say, to the ordinance, to the language of the ordinance itself, bodes the question, why are we even going through this? And this is why I've requested the city commission to get involved, and would like to further get city administration involved.
Okay, I hear you. I appreciate your arguments.
And if I may, one last thing.
Go ahead.
These are new owners in the city of West Palm Beach. Okay, one thing that I've been involved in government for the past 15 years. One thing I've learned when people come into ownership inside a municipal boundary is that there can be an insurmountable amount of ordinances and rules and regulations that no one is privy to. And I'm bringing that up to say this: these owners and managers of this new establishment have gone out of their way and bent over backwards to learn and to identify what the do's and the don'ts are, and whatever it was subsequently being done wrong, figure out what they can do to make it right. So this ownership is by all means committed to working with the city and being a partner with the city of West Palm Beach, not being an adversary or being a nuisance. This hearing today is impeding on the owner and the city, quite honestly's ability to create and forge a partnership that's going to last beyond just present day. And again, no disrespect to either officer, because they've done an impeccable job at maintaining the rules and the regulations of their responsibilities. So I appreciate you both. So this is not a reflection of you in any way, shape, or form. This is, however, an opportunity for the city and for these owners to come onto the same playing field and make sure that we're working cohesively to ensure that no violations are committed moving forward in the future.
Okay. I guess one question, and whoever can answer that you think is best, but after issuance of the warning notice, what was done on the part of the respondents to try to mitigate the noise?
Again, they testified to making changes to the door.
To the front door. Anything to the patio?
Have, soundproof it.
Mm-hmm.
And then they also have the decimal meters. And I actually brought pictures of the decimal meters that they actually have, and they have 3 different types so that they can measure the sound. And that's why it's very imperative that we recognize and establish that there is, I know the city is stating that it's their city ordinance and it's just a plain audible sound, but again, with respect to a lounge, you need to have a measure so that it's not based on personal, observation, or that it can be subjective by an individual, because me hearing an audible sound versus an old person and versus a kid, it's different for each and every one of us.
Okay.
To definitively answer your question on what was done on the patio, that's when the sound projection was turned in the opposite direction from the municipal boundary to ensure that it projected away from municipal boundary lines.
Okay. All right, thank you for that. We got a spicy one here today. Let me ask the city to respond as it relates to the arguments just made about 3436B9A.
So I understand that that's included in B9A. The city is pursuing, or is proceeding here today under 3436 generally, and 3436A states that it shall be unlawful for any person to create a noise, disturbance by making, continuing, or causing to be made or continued any unreasonably loud, excessive, unnecessary, or unusual noise that is plainly audible. And then the factors that may be considered are factors that the officers have testified here to today, including their plain observations and the observation that the noise was audible from the source and greater excess of 25 feet from the source.
So is the city's position that it's not required to find a violation of 3436B9A in order to find a violation of 3436A?
Yes, that's correct.
Okay. All right, let me ask respondents if you have anything further you'd like me to hear before I make a ruling.
Again, Your Honor, I'm going to harp on the fact that we need a continuance to ensure. I understand this was given back in December. These are new owners, new property owners. So this is something that they've, amongst other many issues, they have been working on very diligently to learn how to go about mitigating the situation. And, this is something deeper than just bringing council on board, because you're now learning how to have to deal with a whole new book of laws, and that requires participation from city commission, city administration, and others who are key players in the community that could assist with this moving forward. So, in order to substantiate why this violation should not go into effect present day, allowing for grace to be given, would like to produce all of the evidence that has sustained for the past 20 years in this exact same establishment, just under different owners, that would, again, substantiate the use of this backdoor patio and how it has been utilized and how this has never, ever been an issue before. And I think that would play an integral role in your determining whether or not this one isolated incident back in December has now ballooned into a much larger issue because of previous disgruntled tenants that until now, have never caused any additional attention to this property.
Okay. All right, thank you for that. Anything from you, Ms. McLean?
Yes. What I'd like to add is, Mr. Jackson is correct that my client are new owners, but they were tenants long before they became owners of the plaza. So,
At this location?
yes,
Okay.
correct. Since 2019, maybe longer before that. But they were tenants before, so they've always owned the lounge area.
Uh-huh.
The other thing that I would like to state is that they have gone beyond to try and mitigate the situation by making changes, and they've already expensed a lot of funds in doing so. So I do understand there's a fine of $500, but I would like for today that if that fine can be waived or reduced, if anything, because today you're actually setting a precedent for officers to still come back on the property, sit on the property, and just wait for them to hear something and then issue another citation. So this is not, in terms of if you find in favor of the city today, it's gonna be a big problem. Especially, again, because it is a lounge.
Okay. All right, thank you. Let me ask, I guess I didn't ask you this previously, so let me ask you this now. The documents that have been scrolling on the screen there, which include the citations, I think your letter is included in there, dated December 12th, 2024. Could we scroll through those documents and just at the end, let me know if you have any objection to those documents being entered?
I do have an objection.
Go ahead.
The one where the $500 $500 fine is issued, it says describe the nature of the sound, and it says loud. It's really not descriptive. We don't know what that is. It does not comport with any statute or even citation. I believe he actually should define what loud is, like they did with the first one where it was just a warning and it says music and bass speakers. So again, for today, I would appreciate it if the commission would have a zero fine for today.
Okay. All right, any other objections to the documents? Just that one?
Just, hold on. Can you scroll?
And that's
again so I
essentially a
can-
merit objection, but
Wait,
I hear
Can
it.
you scroll again so I can see all of them again? The citations. That's it.
All right, no other objection?
No other, just the one.
Okay. All right, with that, in case PD 25020442, I'm going to admit the city's evidentiary case files composite exhibit 1 over objection. I've heard final words from respondent. Anything further from the city?
Just a few points, Special Magistrate. So with regard to the property being unaware of what the laws are publicly available, and particularly as applicable to the fine that was issued on December 6th, they were issued a warning, written warning, just a few days prior on December 2nd. So as far as not having knowledge or notice of what the law that's applicable to their property is, I don't know how that could be when they were served a written warning on December 2nd and then they were fined for the first offense on December 6th. So this fine is based on the personal observations which was provided by testimony by 2 officers that are here present today. It's not, these fines and the citations and written warning weren't based on anonymous complaints. They're based on the personal observations of these officers as required by our code under 3436. Pursuant to 3444, a warning is only required for the first offense within 6 months, which was given a few days prior before the fine was issued. The fine, which I know there's been discussion of, or it's been brought up that, there should be a reduction or a waiver of the fine. I'll just state on record that under 3445, the enforcement of this violation provides that a violation, a first offense, shall be punished by a $500 fine. And to me, there's no wiggle room there, and that's all from the city right now. And if you have any questions, happy to answer.
And that was going to be my question to you. So that's set by ordinance, okay. All right, with that, hearing the testimony of both sides, the witnesses that both sides have called, the cross-examination of, by both parties of all witnesses called in this matter, I've entered the city's evidentiary case file into the record. Given that this is a citation hearing, I'll find that, and given the presence of all parties, that any requirements for requests for administrative hearing and any notice requirements have been satisfied, given that all parties here are present, and I've heard no disputes relative to everyone's appearance today. Based on, I appreciate the arguments of respondents' counsel and respondents' representatives. You know, sometimes being in this chair is a little bit difficult because I appreciate your testimony of what's gone on that property and what's allowed or has been allowed in the past. But as I sit in this chair this morning, my only job is to enforce the ordinance that's on the books now. So I don't dispute with you that maybe there's an opportunity for an adjustment to the city's code to, you know, relative to what's going on that site, especially if it's been going on for 20 years. But that's a policy decision, and I'm not a policymaker. That's something that, as the representative who is here suggests, that maybe there's discussions with city administration and the folks who set policy in the city. But my job here and is to look at the facts that both sides have presented today and you know, compare those facts to the code that's on the books today. And the testimony is very clear. The evidence is very clear that there's a violation based on the testimony of the officer, based on the language in the code, which states that there can't be plainly audible sound at more than a distance of 25 feet. So, and I haven't heard any testimony as you know, negating that or suggesting, other than the decibel readings, which are not required by the current city code, that the noise wasn't audible at that level. So the city has met its burden to prove the violation, at least as it relates to 3436A, in terms of there being a plainly audible sound that was heard by the officer who testified at a distance of more than 25 feet. The exact distance was 250 feet. So as I sit here today, I'm going to find, based on the testimony that's in the record, based on the documents that are in the record, the testimony of the police officers who are here and testified this morning, that there is a violation of section 3436A relative to that exceedance of the 25 feet, given the citations that were issued and on those dates that are cited in that citation with regard to when the noise was heard. I'm not going to find a violation on 3436B9A. I don't believe the city has put on enough evidence to prove that violation, so my order will only reflect a violation of 3436A. For the citation that was issued in December, on December 6th, just so the record is clear. I am going to, because I don't read the code to allow me any latitude, I don't have latitude to mitigate the fine at this time. The code says that there shall be a penalty of $500 for the first offense, so given that I found your client in violation, I'm going to impose that fine of $500. I would encourage you, as I think you've alluded to have discussions with city administration if there's a policy decision to change that code in the future. That's not for me to decide today, and the code doesn't allow me to mitigate that fine amount. So I will impose that $500 fine. That's a one-time fine for this first offense for the December 6th violation of 3436A, and you'll get an order that reflects that in the mail, okay? Thank you to both sides.
Thank you.
Thank you.
Thank you.
Okay, next case, number 30-950 Golden Lakes Boulevard, CE 2401126, number 30-1950 Golden Lakes Boulevard.
And let me go ahead right now, since looks like we've moved to the fine mitigation portion of the hearing. Let me swear anybody in who's in the room who was not sworn previously. If you're here for an other matter or fine reduction hearing, I think is what all the rest of these are. If you could stand if you're able and raise your right hands for me. Do you all swear or affirm to tell the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, City.
All right, Officer Williams, City of West Palm Beach Code Enforcement. Case number CE 240-11296, agenda item number 30. Case address 1950 Golden Lakes Boulevard. This case was originally cited June 20th of 2023. They were cited for a prohibited signage and banners, I believe it was, on the case. This went to a special magistrate hearing February 21st, 2024. It was ordered for that. The order was bifurcated for both fines that they were cited for. So the first violation, it was ordered for that to come into compliance by May 21st, 2024. The second was ordered to come into compliance June 20th of 2024. And subsequently, both fines were running at $100 a day each for a total of about 84 days, which brought the fine to a total of $16,700. Service in this case was achieved by way of posting as well as regular mail. Magistrate, we do have an agreement beforehand to reduce this fine to, which would amount to 20%, which would be $3,340 payable within 30 days.
All right, names for the record?
Good afternoon, Jeffrey Sluggett with Jeffrey B. Sluggett and Associates, here on behalf of the owner.
And you, sir, are the owner?
Alan Barber with Mint Eco.
Okay. So you've heard what the city is saying. He's telling me that you have a mutual agreement to pay the $33.40 within 30 days. Is that correct?
Yes, ma'am.
Anything else you'd like me to hear?
No, that's it.
Well, that's easy enough. Anything else from the city?
No, ma'am.
All right, in case CE 2401-1296, I will reduce the, first, I guess, let me enter the city's evidentiary case file. Do you have any objection to the documents that are on the screen? You requested this hearing, so I presume not. Any objection? It's just, I think the request document is all that's in there, right? Okay. No objection?
No objection.
All right. With that, I'll enter the city's evidentiary case file into the record as Composite Exhibit 1 without objection. I'll reduce the fine amount in this case from $16,700 down to $3,340 payable within 30 days. And just make sure you get it paid, because I'm sure, as you know, the fine goes back if you don't pay it. So get it paid within that time, okay?
Absolutely.
Thank you.
Thank you.
Here's a copy of your order behind you. Number 23406 Greenwood Avenue, CE 191101146. Looks like there's multiple cases. Number 21 for the same address, CE 10050501. Number 22, CE 11070437, and number 24, CE 22060091.
Would you like to take them one at a time, Magistrate, or do you want to hear them all at once?
You can go ahead and read them all in at once, and then I'll order individually.
Okay, sounds good. All right, so for agenda item number 20, case number CE 191-10146, case address is 3406 Greenwood Avenue. This case was originally cited November 8th, 2019 for inoperative vehicle, exterior paint needed, and also to renew the rental license and certificate of use. This went to a special magistrate hearing December 4th, 2019. It was ordered for that fine to start as of January 6th, 2020. That ran for 60 days at $200 a day for a total of $12,000. And this was complied March 6th of 2020. Service in this case was achieved by way of posting as well as regular mail. Magistrate, we do have an agreement beforehand to reduce this amount to $1,500 payable within 90 days.
I presume you have agreement on all of them?
Yes, ma'am.
Okay, so then let's go ahead and do them each individually. That way
Okay.
we'll deal with them one at a time. Your name, sir?
Charles Frederick.
And you're the property owner?
No, I'm representing the property owner.
And they know you're here today?
Yes.
Okay. So you've heard what the city is saying. They're saying that you have an agreement to reduce the fine from 12,000 down to 1,500 payable within 90 days?
Yes, Your Honor.
Okay, you're in agreement with that?
Yes.
All right, anything else you'd like me to hear on this one?
Not at all.
All right, in case CE 19110146, I will grant the mutually agreed reduction and reduce the fine amount from 12,000 down to 1,500 payable within 90 days.
All right, for agenda item 21, case number CE 100505001, same case address 3406 Greenwood Avenue. This case was originally cited May 17th of 2010. They were cited for a failed inspection due to a expired rental license and certificate of use. This went to a special magistrate hearing July 21st of 2010. It was ordered for the fine to start as of August 26th, 2010. That ran for 187 days at $100 a day for a total of $18,700 and was complied March 1st of 2011. Service in this case was achieved by way of posting as well as regular mail. Magistrate, we do have an agreement beforehand to reduce this amount to $2,500, also payable within 90 days.
All right, sir. You've heard the city's commentary. You're in agreement with the $2,500 payable within 90 days?
Yes, we are.
Okay, anything else you'd like me to hear?
No.
All right, in case CE 100-50501, I will grant the mutually agreed reduction and reduce the fine amount from $18,700 down to $2,500 payable within 90 days.
Okay. Agenda item number 22, case number CE 110700437, case address 3406 Greenwood Avenue. This case was cited in July 25th of 2011 for a boarding secure permit needed, cut and clean of the property, as well as trash and debris present on the property. This went to a special magistrate hearing September 21st, 2011. It was ordered for the fine to start as of October 25th of 2011. That ran for 273 days at $100 a day for a total of $27,300 and was complied July 24th of 2012. Service in this case was also achieved by way of posting and regular mail. We do have an agreement beforehand, magistrate, to reduce this fine to $2,500 as well, payable within 90 days.
All right, same thing, sir. You've heard the city. You're also in agreement with the $2,500 payable within 90 days?
Yes.
Okay. Anything else you'd like me to hear?
No, Your Honor.
All right, in case CE 110700437, I will reduce the previous lien amount from $27,300 down to $2,500 payable within 90 days.
Okay, for agenda item 24, case number CE 220600091, case address 3406 Greenwood Avenue. This case was originally cited June 9th of 2022 for failure to obtain a certificate of use, rental license, outdoor storage, and excessive overgrowth of the yard on the property. This went to a special magistrate hearing July 20th of 2022, and it was ordered for the fine to start as of September 19th of 2022. That ran for 347 days at $100 a day for a total of $34,700 and was complied September 1st of 2023. Service in this case was achieved by way of posting as well as regular mail, and we do have an agreement beforehand, magistrate, to reduce this fine to $3,500, also payable within 90 days.
All right, in this case, you're in agreement with the $3,500 payable within 90 days. Is that correct, sir?
Yes.
All right, anything else you'd like me to hear?
No, Your Honor.
All right, in case CE 220600091, I will grant the mutually agreed reduction and reduce the fine amount from $34,700 down to $3,500 payable within 90 days. Thank you, sir. She'll give you orders, I think, right now.
Yes. Number 29, 600 South Dixie Highway, 237, CE 22010406. Number 29, 600 South Dixie Highway, 237.
For agenda item number 29, case number CE 22010406, case address is 600 South Dixie Highway, Unit 237. This case was originally cited January 28th, 2022 for failure to obtain a rental license as well as a certificate of use. This went to a special magistrate hearing April 6th, 2022, and was ordered for the fine to start as of May 9th of 2022. It ran for 387 days at $200 a day for a total of $77,400 and was complied May 31st of 2023. Service in this case was achieved by way of certified mail posting as well as regular mail. This was done under the previous owner, so the city requests a reduction of 15%, which would be $11,610.
All right, your name, sir?
My name's Stanley Alfont.
And you are,
I'm the previous LLC owner of this property.
you're the previous or the current?
Previous, so I was owner of Prado LLC, Alfont Prado LLC, but we had to protect some assets, so we did like a building sale where Valley Brook had to come in and just purchase this property to protect our assets. And that lien amount is currently held in escrow, and he's basically just holding it there, like.
Okay, does the new owner know that you're here?
Yeah, I actually have an email from him saying I can act on Valley Brook's behalf.
Okay. Has the city seen that email?
No.
Can you show that? Do you have it with you by chance?
It's on my phone.
Yep, you can touch it. This is just code enforcement, don't worry. You can go over to him and show him. And then if you would, just go ahead and read it to me, what it says into the microphone.
So this is from Brian Dempsey. Stanley, please provide this email to anyone who may require it. Stanley Alfont is designated to be Valley Brook Homes LLC representative today at the hearing associated with Unit 237, located at 600 South Dixie Highway.
Okay, very good, thank you. So you've heard what the city is saying. I guess let me ask the city staff, how many prior code cases on this?
Just one under their ownership.
Just one, okay. So they're asking me to reduce, or they're recommending that I reduce this down to $11,610. What's your response to that number?
I'm okay with that.
Okay. You're good with that number? How much time do you need to pay that? You need 90 days?
Within 90 days as possible.
Okay. All right, anything else you'd like me to hear? No?
All good.
Okay. All right, anything further from the city?
No, ma'am.
All right, in case CE 22010406, I will grant the reduction. I'll reduce the previous fine amount down from $77,400 down to the mutually agreed number of $11,610 payable within 90 days. So like you heard me tell the previous person, make sure you pay it within that time or the lien goes back to the original amount, okay?
Money's ready, in escrow, ready to be spent.
Ready to be paid, perfect. She'll give you the order there before you leave. Thank you, sir.
And I don't see anyone else present, so the rest of the matters are rescheduled. Number 23, 1333 Palm Beach Lakes Boulevard, CE 22080006. Number 26, 1927 Windsor, CE 22090220. Number 27, 1909 Windsor, CE 221200197. Number 28, 1927 Windsor, CE 221020195. And that's it.
And that was quick. All right, anything further for the magistrate?
Ma'am.
With that, I'll adjourn this hearing at 12:32. Thank you.